Good afternoon. Welcome to the Appellate Division First Department. As I call the calendar today, please ask for the time that you actually need. About 5.5 hours time has already been requested, and we obviously can't do that. Remember that if the panel and I or I have additional questions past the time you've been allotted, we will ask them, and you'll have an opportunity to answer. Remember, we have read your papers and are familiar with the issues that underlie your appeals. For those of you here for the first time, you should know that the white light on the lectern will go off when you have 2 minutes left to your argument, or if you've asked for less than 2 minutes, it will go on immediately. When I call your case, rise and let me know how much time you are requesting. People v. Shannon McCollum. Three and one and three. Jeddah versus Jeddah.
8 and 2 for the plaintiff.
Anybody else here?
Yes. Sorry, for the respondent, non-party, Bruce Pfeffer, 8 minutes is fine.
Okay. I'll give you 5 and 2 and 4. M. Prince is submitted. Kingstone Insurance versus Marion Pharmacy. Right, 3 and 1, but I don't know if your opponent's here.
Unless the panel has questions, Your Honor, I'm happy to submit.
We'll submit. Thank you. Damari Services versus Queen's Medallion.
Appellants, 3 and 1.
Respondent, Scottish American, 2, please.
Okay. 3 and 1 and 3 and 2. Brown versus Tishman Construction.
Appellant, 10 and 3. Since we're both appellants, I would ask for 6 and 4.
I'll give you both 6 and 2. Thank you. York v. Tappan Zee, we've got 3 appeals on that one.
Appellant respondent, LP Electric, 2 and 1.
2 and 1? Very well.
Respondent, appellant, Tappan Zee requests 3 and 1.
Okay.
Respondent, appellant, plaintiff requests 6 and 2, please.
Okay. I'm going to give you a little bit more time. 5 and 2, 5 and 2, and 5 and 2. People versus DeAndre Holder. Submitted. Xerox Corporation versus Travelers Casualty.
Your Honor, counsel for Xerox Corporation, respondent, also appellant, we request 10 minutes and 5. And for Travers, 10 and 5 respectively, Your Honor.
I'll give you 8 and 2 and 8 and 2.
Did you skip Holder?
Did I skip? No, the Holder's on submission, I think. People v. Holder, did I not call that?
You did.
I thought I did. Anyway, so submit. Tabor versus 391 Broadway.
The appellant, 10 and 3. Respondent, 3, please.
I'll give you 6 and 2 and 3. Cabrera versus Golden.
Golden, 8 and 2.
Okay, I'll give you 6 and 2, 6 and 2, and 5. 49 East Owners versus 825 Broadway.
I'm here for respondent, unless the counsel is happy to have it submitted.
We'll take it on submission. Thank you. People versus Antoine Spencer. I'll give you 6 and 2 and 6. Perone versus Perone is submitted. Scaludi versus Kiriakou is submitted. Okay, we'll call the first case, People versus McCallum.
Medallion is here.
Good afternoon, Your Honors. Ashley Baxter on behalf of Appellant, and may it please the Court. Your Honors, Mr. McCollum's sentence was excessive and should be reduced to the statutory minimum of 3.5 years to be followed by 2.5 years post-release supervision.
Counsel, why should we rule on defendant's excessive sentencing claim when we're going to remand to the sentencing court anyway?
Yes, Your Honor. That's because the excessiveness of Mr. McCollum's sentence is before this court, and this court has the interest of justice power to reduce his sentence. It's also the efficient use of judicial resources, and it's more efficient to reduce the sentence here.
He
Okay.
has to be resentenced, correct?
Yes, Your Honor.
So are you suggesting that we resentence him?
No, Your Honor.
And what would be the point of deciding what the sentence is and then sending it back for resentencing? And wouldn't it make sense to give that discretion, to give it to the motion court to, and the sentencing court to sentence him?
Right, Your Honor, but if this court were to reduce his sentence and he were remanded for a resentencing, it would just be to enforce his right because he was not present at resentencing.
So what you would have us do is to vacate the sentence, send it back down and say, you have to sentence him to X.
No, Your Honor. What we're saying is this court has the authority to reduce his sentence.
True, but we're remanding, right? Because the people are consenting that he needs to be resentenced because there was a violation because he wasn't present.
Yes, Your Honor.
That's your argument as well, right?
Yes.
So once we do that and we send it back down, shouldn't it be in the first instance for Supreme Court to resentence?
That's
Well,
what we
this-
think, obviously. Do you want to talk about the PRS issue that came up in the sentencing court? There was some confusion about the amount of time in PRS.
So, yes, Your Honor. So he received 5 years for CPW2 and 3 years for assault. But the court incorrectly said it was 5 years each for each offense. And so the court resentenced him twice to correct the error, and twice Mr. McCollum and defense counsel were not present.
So now he's going to be resentenced a third time.
Yes, Your Honor.
Anything further, counsel?
No, Your Honor.
Thank you.
Good afternoon, Your Honors. Jamie Maston for the people. The people agree that what makes most sense here is for this court to vacate the sentence and to remand the case back to the trial courts so that the correct sentence can be pronounced in defendant's presence. Because of that, there is no reason for this court to reach the excessive sentence claim, which in any event is foreclosed by his valid waiver of appeal. Unless there are any further questions as to the waiver or his sentence itself, the people rest on our brief.
Thank you, counsel.
Thank you.
If Your Honors don't have any further questions, we also rest on our brief.
Thank you, counsel.
Thank you.
Thank you both. Jeddah versus Jeddah.
Good afternoon, Your Honors. Peter Schalk of Judd Burstein PC for the defendant appellant, Rachel Barron, formerly Rachel Jeddah. This is a case that the actual plaintiff is not a party to this appeal. It's a little bit unusual, although he has been given notice. This is an appeal concerning conduct of the receiver of a marital estate. Now,
Counsel, that raises the question, why didn't Mrs. Barron, she prefers Mrs. Barron, right?
yes, please.
Why didn't she go in for further discovery after 2014? There was some brief disclosure in March and April 2014, and then nothing else happened.
Well, because there wasn't anything to do until we got the appraisal of the Caesarea property, which didn't happen until December of 2019. So the court specifically held in its original order that Mr. Pfeffer could not be discharged until the Caesarea property, that's that property in Israel, and there was litigation involving that property that lasted all the way into the end of 2019. She didn't get sole title to that property until the end of 2019, and they didn't get an appraisal until December of 2019. So that we could not try to settle this case, and this was fully.
Weren't there other things to talk about before that happened? I mean, Mr. Pfeffer's behavior and
Well, there was the court issued an order in January 2014 saying that Mr. Pfeffer's conduct, it rejected his accountings. He's never had to do an accounting. It found that he had to repay the estate because he paid himself legal fees that were not proper.
But then there was the June 2014 order that specifically stayed the order of reference so you could go ahead and do discovery, and then nothing happened.
Well, then, actually, the court removed that order of reference, specifically said it would reinstate that order of reference, but it was not going to
After
do that
discovery was
until-
done, and no discovery was done.
Well, it was not going to reinstate that order of reference until
Well, what did you do over all those years? How many years was it, like 8 years?
there was litigation in Israel that did not end until 2019. So from 2014 to 2019, and that the court specifically held that the responsibility for the litigation was Mr. Pfeffer's fault because he did not file a lis pendens in Israel.
But what stopped you over all of those years of proceeding against Mr. Pfeffer?
Well, we got the relief we wanted in 2014 to decide how we couldn't know what Ms. Barron's damages were
And then did
until
nothing
she
with that
obtained
relief.
title.
And then did nothing with that. You got the relief you wanted, which would have allowed you to do certain things, and then you didn't do any of those
The
things.
relief couldn't be granted until there was a decision from the Israeli court, and that didn't happen until 2019. And the court below specifically held that the responsibility for that delay was Mr. Pfeffer's fault because he didn't file a lis pendens, and then Mr. Jetta went and sold half of the property to a third party. That had to be litigated, and it was litigated in Israel with estate funds that never should have had to be spent because Mr. Pfeffer did not file a lis pendens. He had the same problem with Mr. Jetta in New York, with the New York properties, where he didn't file lis pendens, and Mr. Jetta went and sold those properties as well, and also encumbered them. So it was specifically agreed and contemplated that we could not try to settle this case until Ms. Barron, A, had title to the Caesarea property, and B, that...
Counsel, both parties in this case engaged in very bad behavior. Why isn't it a fair disposition of this protracted matrimonial matter? Why isn't this a good end, what Justice Cooper did?
Well, because the duty of the receiver is not to any individual party, it's to the estate and to the property of the estate. And if his actions harmed the corpus of the estate, which they clearly did, he is supposed to account. He's a fiduciary, he's the arm of the court. He was a court appointed, that's a high honor, but it comes with responsibilities. And his responsibility was to take care and to follow the judgment of divorce. It is unequivocally clear that he did not follow the instructions in the judgment of divorce. He transferred properties to Richard Jetta, and supposedly in exchange for the Caesarea property, which he didn't even get transferred to Ms. Barron. It had to be litigated over 5 years.
At the end of the day, counsel, what was she going to gain from continuing this litigation against Mr. Pfeffer?
Well, if Mr. Pfeffer if the hearing that the court originally ordered is held and there's a surcharge found, she would share in that surcharge.
So he gave up his fees.
He gave up his, yes, that's correct.
He gave that
his
up.
commission.
So he gave up his commission. She, because of the bad acts of Mr. Pfeffer, she got $400,000 from the estate, right? And then she also got the entirety of the Israel property, which turned out to be like $1.8 million at the end.
1.6.
Was it 1.6? Because there was some
she got the
discussions in the
half of-
transcript that it may have been worth maybe $2 million.
No, it was appraised at 1.6, and that was in December of 2019, which is again the information we needed before we could.
But she's the sole owner of that property because.
She was then, finally, she became solo owner in 2019.
So she ended up getting more money than she would have gotten had Mr. Pfeffer done things maybe appropriately?
Well, what you can't tell is whether or not that's true without having the actual hearing. The other point I'm just trying to make is that Mr. Pfeffer's duty is to the assets of the estate. And the court found that he paid himself inappropriate legal fees in connection with these improper transfers that he was supposed to pay back into the estate. Because he never filed an accounting, we don't know if he paid back those monies.
Well, he filed an accounting, but it was rejected,
That was rejected, but he then never had to file a final accounting. The court specifically rejected his initial accounting and held in the same order that he had to repay the estate for the monies he paid his own without prior court
Thank you,
permission.
counsel. You have time in
I'm sorry,
rebuttal.
I'm sorry. Thank you for your time.
You have time in rebuttal.
Good afternoon, Your Honors. Linda Rosenthal on behalf of non-party Bruce Pfeffer, the receiver, respondent. This court should affirm the trial court's ruling for at least 3 independent reasons. First, under this court's prior ruling in Jasinich, Mr. Pfeffer the claim against him was solely in respect of surcharge. At no time during the pendency from 2008 when Mr. Pfeffer was appointed, 2010 when he proposed the property transfer agreement, through December of 2021 when Justice Cooper finally disposed of this matter, at no time were claims levied against Mr. Pfeffer in his personal capacity. Under this court's ruling in Jasinich, there are 2 paths that a claimant may pursue.
Now, Mr. Pfeffer did some things he should not have done, but I gather from Justice Cooper's decision that he felt that these unauthorized acts were not for personal gain. Is that your principal argument about why we should let this go?
We have a number of arguments, Your Honor, but in truth, I don't believe that Mr. Pfeffer, what the trial court actually found was that Mr. Pfeffer acted at all times in furtherance of the judgment of divorce. Whatever it was in respect.
I don't know if I agree with that characterization, counsel, but please continue.
Pardon?
I don't know if I agree with that characterization, counsel, but it's all right. Please continue.
What Judge Cooper actually said is that at no time did Mr. Pfeffer act for personal gain. No time did he act in any respect to enrich or to prefer one party over the other. And in point of fact, he acted in his judgment to further the aims of the judgment of divorce. The court does say that actually, Your Honor, it's at the record at page 49. So what I would
He
say—
tried to find a solution to distributing
Correct.
marital assets. I saw that. But on
Correct.
the other hand, we cannot have receivers going off and doing this sort of thing without any kind of authorization from the court. Would you agree?
In point of fact, Your Honor, I do agree. Nonetheless, Mr. Pfeffer timely alerted the trial court at that time of this property transfer agreement. I want to note that the trial court at the time actually maintained over Mr. Pfeffer's numerous requests and Mrs. DeJetta's counsel requests to restore the property to the receivership. The trial court maintained the property transfer agreement for almost 18 months. So in point of fact, whatever Mr. Pfeffer did in the first instance, the trial court actually constructively ratified to maintain the status quo. No one could have anticipated that these 2 litigants would have gone rogue in the way that they did. Mr. Pfeffer's actions, whatever initially the reaction from Justice Evans may have been, regardless, she maintained the disposition of the properties in place, and only multiple years later were they in fact transferred back to the receivership after Mr. DeJetta had, in contempt of court, violated numerous court orders by hypothecating, encumbering, mortgaging, and constructively looting the properties. But once Mr. Pfeffer notified the trial court, the initial trial court, the appointing trial court, of the property transfer agreement, and the trial court declined to restore the properties back to the receivership, he was no longer empowered to take any actions in respect of those properties. So in respect of Mrs. DeJetta's claims, what the trial court found was actually the relief that she sought was rightly compensated by virtue of Mr. DeJetta, by virtue of the court modifying the judgment of divorce. She walked away with approximately $2.6 million. In the final court appearance in December of 2021, as the court is well aware, Judge Cooper also awarded Mrs. DeJetta an additional $58,000. Mr. Pfeffer abandoned, he voluntarily relinquished his commission. Exactly as Mr. Schock said, the receiver is in fact an arm of the court. He's entitled to judicial immunity, and hence the surcharge can only be exacted from the properties within the receivership or from the commission. Without a commission, and with the judge having determined that Mrs. DeJetta had received a disproportionate amount of the equitable distribution of the marital pot, i.e. the receivership properties itself, there was nothing more for her to pursue.
Thank you, counsel.
Thank you.
Briefly respond? One, for latches, there has to be prejudice. There is no prejudice here whatsoever. Two, very importantly, when Mr. Pfeffer first went to the court, that was on the 22nd of March 2010, Justice Evans said, I am not approving it specifically. He then recorded the deed the next week, 7 days later on March 29th, 2010. So he went and let Mr. Jetta rob the property a week after the judge said, I am not approving this deal. And she did say, Justice Cooper did say some things in December 2021. They're entirely different than what he said in January 2014. What happened? Nothing but the passage of time. There is no reason to find good faith on the part of Mr. Pfeffer without a hearing, and to have intent, you have to have a hearing. Does the court have any questions for me?
No, thank you, counsel. Thank you both.
Thank you for your time.
Damari Services versus Queen's Medallion. Please.
May it please the court, I am Dylan Murphy, here to appeal the order which granted two 3211 motions to dismiss the complaint filed by the residential board of the Century Condominium and Damari, a Century Condo building contractor. Which, with respect to the main issue on this appeal, that is whether the complaint's causes of actions against two insurance brokers are premature because the underlying Guerrero action is not yet resolved, the answer is no. The lower court improperly relied upon a 40-year-old third department decision to dismiss the complaint.
Right, and the authority in the first department is different than that, correct?
Yes, Your Honor.
That's your argument.
I'm sorry, Your Honor?
That is your argument, right?
That is the argument, Your Honor.
Even though the damages haven't been quantified in the Guerra action, there's still the potentiality of damages is sufficient to create a tort cause of action here.
Yes, Your Honor.
Anything else?
With respect to the promissory estoppel and breach of contract claims as set forth in our breach, we believe there was consideration by the appellants for the breach of contract claim, and there was reliance by the appellants upon the respondents' email confirmations of coverage, which came before Century executed.
Wasn't your contract made before that? Wasn't your contract made before that?
No, the contract was formally executed on April 17th, 2017.
But isn't there a signed contract in February? Isn't there a contract signed by both sides in the record in February 2017?
It's dated February 16th, 2017.
Well,
Isn't that the date we should be guided by?
Well, during discovery, the plaintiffs will explain that it was actually signed on April 17th, 2017 by Century. Century did not enter into the contract until after the email confirmations of coverage.
Is there support of that in the record?
Yes, there are two affidavits in the record which are cited in our briefs.
Where in the record would we find those?
The affidavits in the record in the underlying action are located at the affidavit of Craig Schiller is at 465 to 469, and the affidavit of Eric Lyons is at 478 to 481. The appellants were damaged by the coverage disclaimers. They have justiciable claims against the insurance brokers, and they asked the court to reverse this decision and reinstate the complaint.
Thank you, counsel.
Thank you.
Good afternoon. Christina Riker from Wingett Spatafora in Schwartzburg for Respondents Queen's Medallion. First, I'd like to address something raised in appellant's reply brief that is, I believe, incorrect. One of the reasons why Judge Bannon granted the defendant respondent's motion to dismiss was finding that the contract was signed on February 16th, 2017, based on the evidence of the record. And she deemed the affidavits that counsel refers to as not compelling based on the record. And one thing we raised in our opposition brief is that in addition to everything, the contract that was dated February 16th, 2017 and signed.
No question the draft of the contract, I mean, even accepting appellant's version of the events, there's no question the contract was, the draft of the contract was submitted in February, right? That there can be no disagreement about, am I right?
That's
Maybe
correct.
it's even January, but definitely February. Is that draft changed? Are there any changes made in that draft?
Not according to any of the documents in the record, no. And in fact, in the third-party complaint in the underlying action, the plaintiffs admit that that contract was entered into on February 16th, 2017. On page 227 of the record, in the third-party complaint, it says the plaintiffs' appellants themselves say on or about February 16th, 2017, for good and valuable consideration, Damari entered the agreement with defendant third-party plaintiff, which in that action was the Board of Managers for Century Condominium, regarding construction work to be performed at the construction project. The indemnity and insurance provisions of the agreement were in full force and effect on the date of the incident alleged in plaintiff's verified complaint. Now, the plaintiff appellant argued in his reply brief that that complaint was not verified, and so the court should disregard those assertions in their own pleading. But I have a First Department case that says to the contrary. In U-Trend NY Investment LP versus U.S. Suite LLC, 186 AD 3D 438, First Department 2020, the court held that facts admitted in a party's pleadings constitute formal judicial admissions. In that case, the complainant issue was an unverified complaint. So I just want the court to be aware that they can rely on those admissions as well. And I'll take any questions the panel has.
Thank you, counsel.
Thank you so much.
May it please the court, Howard Kronberg for Scottish American respondent. I think the question by the court about the difference between the Coutreau case, which counsel referred to, I think you're referring to Lavendier, which changed the accrual for damages based on the Court of Appeals case in Kronos to when the carrier disclaims. My firm was formerly Lustig & Brown. I was one of the attorneys on the Lavendier case. It doesn't apply here. That case was where there was primary insurance that had the obligation to defend and indemnify. Carrier denied coverage. So at that point, the policyholder had to go into pocket for damages. They had to pay for lawyers. They had to defend themselves. That is not the situation here. At worst, there's $12 million of insurance for the appellant. There is their own primary policy. They're being defended by the primary policy.
Primary policy is the mill?
Yes. $1 million, their own primary, $1 million additional insured coverage that is defending and indemnifying them, and then $10 million of their own excess. And in reality, what we're talking about is, we're not talking about the board. If there is any uninsured exposure, it's going to wind up with a special assessment to the unit owners in this building. It's a condominium. At that point, they would have the right to sue the board for malpractice, as well as the attorney and their real estate manager, who all approved of the interpretation of the residential exclusion.
So Scottish gets off scot-free at that point?
In that case, Judge, yes, because that's what the law
Do you
says.
think the board would have the ability, would have standing to assert that interest on behalf of the unit owners?
That's an interesting question, Judge. I've litigated a similar issue in Nassau County up to the Second Department for 10 years on a Sandy claim. And I have to say, I think there would be an inherent conflict of interest because the individual unit owners' interests are not the same as the board. And there is triggering the board's D&O coverage, as well as the malpractice policy of the attorney and their real estate manager, Douglas Elliman, and having their policies, because they would all come before you would get to the excess endurance policy, which is an additional insured excess policy. I see my time's about up. I would like to just read one quote, if I may, from the third department case that we're talking about. It says, "It is alleged that the defendant insurance agency failed to procure a proper policy of excess insurance coverage for the plaintiff, period. It is only after exhaustion of the primary insurance that plaintiff can sustain any damage as a result of a denial of coverage under the excess policy."
Counsel, we're familiar with what the third department says, but our department said something different. So why is that binding on us?
I don't believe the cases in this department are different.
Thank you, counsel.
Thank you.
Counsel, I'd like to start with the citations to the record that you gave us to show that the contract wasn't actually signed until April. One of the documents you sent us to was an affirmation by counsel, who obviously didn't claim to have personal knowledge of when it was signed. The other one was an affidavit executed by the general manager of Century, who was also not the signatory, and he recites what the signatory was relying on in signing it, but there's no indication that he had personal knowledge of any of that. So if that's what you're relying on, there's nothing there that shows that the contract wasn't signed until April. Unless I'm missing something, but neither of those are on personal knowledge.
Yes, and here, the date of the signing of the contract is in dispute.
Well, nothing puts it in dispute because the only people putting it in dispute have no personal knowledge of it.
Well, the allegations of the complaint on a motion to dismiss are deemed admitted and true. These are not summary judgment motions.
Except when it's contradicted by actual documentary evidence, which is what we have in this case. We have a contract dated in February.
And it is disputed that it was signed in February by two affidavits.
Which are not on personal knowledge, and therefore they don't actually dispute it.
And they are not on personal knowledge, and that's why this case needs to proceed to discovery.
Counsel, maybe.
Thank you.
But there's no disagreement that the draft is from February, and no changes were made from that draft to that draft.
To the extent that changes were made, it's not relevant to the case. The fact of the matter is that it was not.
Isn't it relevant to the reliance issue?
Well, the fact of the matter is that Century was not signing the contract until it was satisfied that it had the insurance that it had contracted for. As such, Century engaged in back and forth with the brokers to determine that the insurance was up to snuff. And they wouldn't sign the contract until they had that satisfaction. And that's why they did not sign the contract until April 17, 2 weeks after the April 4 email confirmation of coverage was sent.
Thank you, counsel. Thank you all.
No. He had a good comeback. Yeah.
Brown versus Tishman Construction.
Please the court. My name is Daniel Mink. I represent Brown, who's actually an appellate and a respondent, but I'll speak to the easy one first. This involves a tripping hazard in a construction site on the 60th floor of a large construction building where an iron worker is walking and trips on rebar.
Counsel, an issue in this case is whether or not what he tripped on was consistent with the work being done. As I'm sure you're aware, that's a central issue in a case that was argued before the Court of Appeals a few weeks ago called Bezdarek. Do you think that, what is your view as to whether the Court of Appeals decision in Bezdarek may be relevant to how we would decide this case?
I'm sorry, I'm confused about what you're requesting.
I'm asking you whether you think that the Court of Appeals decision in Bezdarek will be relevant to the issues in this case?
Okay, well, we're talking about the 241.6. I'm talking about the general negligence provision on section 200 of the labor law.
Okay, I'm talking about the provision concerning whether the accident is, whether the rebar was not debris because it was consistent with the work being performed at the construction site. That's an issue in Besdaric. I'm asking whether you think that will be relevant to our decision of this.
Okay, well, are you speaking about the means and methods argument?
No, she's not talking about common law or 200. We're talking about 241 sub 6, integral to the work.
Okay, right, so
You ask us to ignore the Besdaric decision, which Judge Gesmer referenced, which is, even though I dissented in that case, that is stare decisis. That is res judicata. It's not something we can just ignore. It's out there, and doesn't it defeat your claim under 241 sub 6?
So 241.6 is what we're appealing from on, we're also defending section 200, which
Right.
is,
We're asking about 241 sub 6 now.
okay, fine. I started off with 200, and excuse me, please. So the 241.6, the integral to the work argument, okay? The question about what's integral to the work. So are you going to say that something that's not necessary is integral to the work? Here, this is not a necessary risk. There's a difference between necessary risks and unnecessary risks in that case. If the work, this is simple work, there's rebars crossing a path. If the expert affidavit we put in, it could be put in the opposite direction, not perpendicular, but lateral. There would be no risk. The important thing about integral is if you had a 2-ton beam and it was on a hoist and there was no other way to install it except in a risky manner, now we're talking about integral to the work. If you have to use an acetylene torch and the torch causes a pop in the steel.
But counsel, they are working with rebar. That's what they're doing.
Yes.
They are building, putting together a beam, and they're using rebar.
Yes, they are using.
And so the worker, Morales, is piling up the rebar that he's going to use to put together this beam. Whether he piles it the right way or not, I believe it would go to your 200 and to your common law negligence claim. But whether or not the rebar is having the rebar where he had it was in and of itself a violation of the labor law 241.6, then we have to look to see whether or not the rebar was an integral part of the work.
So, but integral does not mean a free pass on any intentional risk. It means necessary risk. Risk that you create. You can't give a free pass to anything on a construction site that you can cause any type of risk that's unnecessary. Here, he's putting scattered rebar in a pathway. It's totally unnecessary. If you want to extend it to anything on a construction site,
Counsel,
well, fine.
we're judges, we're not construction managers, and we looked at the photographs of the roof, and it was pretty crowded up there. So are we supposed to get into the weeds and tell Mr. Morales where he puts his rebar when he's using the rebar at the time?
No, but we did have support. We had an expert. It's a question of fact. You're raising, are we supposed to guess? That's a question of fact. What I'm saying is, at a minimum, maybe I have a question of fact on the question of whether it could be an avoidable risk. Even in medical malpractice cases, there's an assumption there's a risk, but not if it's not a reasonable risk and not if it's not an avoidable risk. That's the law. You can't just say everything's a risk in any case. And what you're implying here is that no matter what they did with the rebar, no matter where they put it, they're using it.
Counsel, here the plaintiff had traversed over the pile of rebar several times successfully. And as I understand it, maybe you could clarify for me, he didn't trip on the rebar. What caused them to fall was that Morales lifted the rebar as he was going over. How does that impact your analysis?
Okay, because the materials were in a dangerous place and he was working in an obstructed place.
But he successfully went over it several times. It wasn't until Morales lifted it as he was going over that he fell.
Well, that is true. That's what happened, but that doesn't alleviate the fact that he's doing it in an unsafe manner in an unsafe location. What I'm saying is you'd really, by extension of the argument in Bandera, say, okay, anything that happens on a construction site that isn't integral to the job, everything is integral to
Just
the
to turn
job.
your attention to the 200, what evidence is there that Tishman had control of this situation?
Because we're dealing with constructive notice, negligence. This is a negligence cause of action, Section 200. This is a plain.
Well, is it means and methods, or is it a premises issue?
Well, they had site supervisors there. This was their job, site safety. This is a plain vanilla site safety, a passageway obstructed. They worry about passageways, slipping hazards, tripping hazards, wearing your safety belt. They have sites.
What do they do on a daily basis at the work site?
I'm sorry,
What did they do on a daily basis at the work site?
There's testimony that they told them, don't put it here, don't put it there. There's testimony and support, and that's why we sustained our claim, because there is actual testimony that's attached to this case. So their site safety person, that's their primary function. Keep everything clear, make sure there's no tripping hazards. This is not like a remote landlord that has nothing to do with a job site. This is Tishman running the safety.
Thank you, counsel. You'll have time in rebuttal.
Okay, thank you very much.
Good afternoon, Your Honors. May it please the Court, Kevin Pollack from Fabiani, Cohen and Hall on behalf of the defendants. Since we've been discussing 241.6, I guess I'll start there. One section which we didn't talk about is 2.1A.
Well, since we're starting with 241.6, perhaps you could answer the question I asked counsel.
Yes.
Which is what the relevance you expect will be of the Court of Appeals decision in Besdaric to this case.
I can honestly say I have no idea what the Court of Appeals decision
Obviously, we don't
says.
know what they're going to do, but I mean, given the issues, I assume you followed it, and whether you think that it's likely that that would have any impact on how we would handle this case.
Your Honor, I have no idea what's in that decision. So I do know that based upon precedent from this court, this is clearly integral to the work, the rebar, that's crystal clear. It sounds like the Court of Appeals agrees with that. So again, in all honesty, I have no idea what that Court of Appeals decision says, so I can't comment on it. With respect to 2.1A, it is also crystal clear that this rebar pile was in active use by Mr. Morales, and since it was being used and not stored, that rule clearly doesn't apply in addition to the 1.7 section, since the rebar work was integral to the work that was being performed.
So your point is that it's not really being, quote, stored, it's being used.
Correct. The entire rebar was, I mean, you can't use 20 rebars at once to install them where he was putting them, one at a time. So yes, the pile was there. The testimony even from the plaintiff was that he brought them there to use them to do his work.
Actually installing it at the time.
100%, yes. The plaintiffs have some, so it's clear that it was in use, the rule doesn't apply and it wasn't violated.
Was it running athwart a passageway, which would be another industrial code section, would be implied by that or implicated by that?
Well, I mean, 1.7 E1 talks about passageways.
You're right, E1.
However, the fact is that since this was integral to the work, whether or not it's a passageway is irrelevant because the rule can't be violated if the work, the rebar installation, and the rebar he tripped on was integral to the work. Plus, I think Your Honor mentioned you looked at the pictures, and I think if you do look at the pictures, which is at record 648, which is...
It's pretty crowded up there.
But there's no passageway. The plaintiff himself who authenticated these pictures said that it was an open deck, open to the sky, no walls.
I know, but there was so much stuff up there. I know it was an open deck. He did say that. but it looked like there were areas that you could walk and then areas that were piled with construction stuff. And so therefore, that would circumscribe what you could do in terms of walking around up there.
Well-
And also, it's true, isn't it, that the plaintiff also made this passage back and forth several times before he tripped?
There's case law from this
Is
department.
that correct, counsel? He did,
He
right?
did make several trips back and forth.
He walked the same way. So doesn't that give some rise to an inference, a potential issue of fact that it was a passageway?
No, because simply because a worker walks someplace doesn't convert that place to a passageway. And that's what this court said in Delana. And just because he walked, if you walk back and forth in an open field the same way every time, doesn't make it a passageway. Same thing with this. This was an open area. The picture clearly shows at 648, it's just a wide open area. And there's no passageway. The plaintiff called it a hallway, but no matter which way you slice it, it was just an open area on the roof. The fact, again, the fact that he was walking back and forth doesn't make it a passageway. And I believe as well, since the rebar that was involved was an integral part of the work, I believe that eliminates that code section from consideration.
So before your time is up, let's turn to Labor Law 200.
Yes.
Why isn't there an issue of fact as to Tishman, since isn't there evidence that they sometimes told the plaintiff what to do? They're on the scene.
No, this is a classic means and methods case, as Your Honor indicated before. The action happens, this is a classic case where one coworker of an employer injures another employee of the same employer.
If they're telling the plaintiff what to do.
No, 100% not. The plaintiff testified, and it's in our brief at page 8. The plaintiff testified that his work was directed, controlled exclusively by Steve Spillman and Ian Rubenstein, both of novelists, and he received no instructions on how to do his work from Tishman or BOP. That's in the record, page 8 of our brief. We cite the record. The judge below made a mistake because the judge relied upon the plaintiff's testimony that Tishman, a safety person, would tell him if something wasn't safe to change what he was doing. And that, based upon cases from this department, general supervision of safety does not constitute control over the work. In this department, there has to be actual supervision of the injury-producing work, which was that rebar installation, which is what Mr. Morales was doing, and that just didn't happen here. So, again, where you have one employee injuring another employee, both of the same employer, that is a classic means and methods case. And since Tishman was not directing that injury-producing work, that claim 200 negligence should both be dismissed.
Was it a Tishman employee that helped him up after he fell?
I believe there's testimony that somebody came by and helped him up, yes.
Do we draw any inference from that?
100% no.
I thought you'd say that.
I'm sorry?
I said I thought you'd say that. All right, thank you, counsel. You have 2 minutes on rebuttal.
Thank you so much.
So there are specific statements that they were instructed not to move the rebar here or to put it here. Tishman, there's testimony in the record. Number two, with regard to the code, we have 23.1.72, which states, and it's a separate section of the code which we cited, and it says working areas, and this is indeed a working area. The parts of floors and other similar areas where persons
Is this
work.
dirt and debris?
Yes, it's.
No, the
cite-
rebar.
This is in
But are we talking about
23.1.7.
dirt and debris? Is it dirt and debris which caused the accident?
Yes, this,
You're pointing to
because it says.
23.172 E2, but that talks about dirt and debris.
No, but materials. And I'll continue reading. It says, free from accumulation of dirt, debris, scattered tools, and materials. It says materials. The word of materials is right in the reg. So this is a scattered material. So there is a specific rule, and these rules are.
The rebar is scattered material.
It is. It's scattered materials. What else is it? It's material, and it's and it's there, it's in the passageway.
But is it scattered if it was placed by a worker specifically so that he could use that to do the work he was doing? Does that make it scattered?
Well, you know, if it's not stored, because it's brought from one big pile to a smaller pile, which I think it is stored. He's not using the 20, he's using one, he's storing the 19. But if you don't want to accept that argument, it certainly falls into working areas, and they're trying to protect this type of risk. That's what these two sections are.
And it goes on to say, insofar as may be consistent with the work being performed.
Well, as I said, if you want to give a pass to anything integral and say it's work being performed, I can do the work in a sloppy, unsafe manner throughout every job, or I can do it in a safe manner and careful manner. So if you want to give a pass to every negligent work habit, then that's what you're going to do, and that's what the court is going to do. I don't think the court meant that. If there's no other way, if you're doing a job, yes, you have to have risk. If there's no alternative, that's what you're looking for. You're not looking to prevent unrealistic safety environment. They have to build a building. But there is a duty, there is an intent to protect normal, casual, careless risks.
Thank you.
That is the distinction from the Court of Appeals. This is just one of those ordinary obstruction of small materials.
Counsel, we take the point. Thank you very much.
Thank you very much.
Your Honor, your question concerns me about passageways, so I just want to go back to that for a second. Again, in terms of 1.7E1, this court has said that the integral to the work defense applies to both E1 and E2. And unquestionably, the rebar was integral to the work. So even if this was a passageway, which I submit it isn't, even if it was, it doesn't matter because the rebar was integral to the work. And one last thing about the argument in 2.1a that 19 rebar weren't being used means that they were being stored. I mean, there's no case that exists that says that. It's contrary to every case in this department where more than one thing is involved in terms of 2.1a. And that would be Brokowski case where a worker tripped on floor tiles that were being used. There was a pile of tiles and he came in contact with it, and 2.1a didn't apply. And in the Tucker case, which we also cite, involved actually a worker tripping on rebar where there was a bunch of rebar. So the fact that only one's being used and others aren't does not take it out of that rule. It's just illogical to interpret that rule called storage of materials to separate the first and second sentences of that rule. I mean, they go together. They clearly both apply to material that's being stored, and clearly the 19 rebar were not being stored. They were being used. Thank you.
Thank you very much. Thank you both.
Thank you very much.
York v. Tappan Zee. Please.
May it please the court, Glenn Kaminsky with the firm Morrow, Lilling, Naparty, counsel for the appellant respondent, LB Electric. And I ask this court respectfully to modify the decision of the Supreme Court so as to reverse the granting of summary judgment to Tappan Zee on its contractual indemnity claim. My argument here is honestly very straightforward, very simple. The court erred in granting contractual indemnity where there are questions of fact as to Tappan Zee's negligence. The court below acknowledged such issues of fact.
What would their negligence be?
They were negligent in the lighting. They were responsible for the placement of the lighting. They were responsible for their laborers to salt the area in question. Their site plan required the gangways between the two barges. So Tappan Zee was responsible. And in fact, the court below properly found that this is not a means and methods case, but this is a dangerous premises case. And Tappan Zee then bears the possibility of being 100% at fault for this. And where there's a question of them being 100% at fault, they cannot be granting even conditional indemnity to that party. So just like we cited we cited Spielman and we cited Scott, in those situations where there are questions of their negligence. And you have to remember here, Tappan Zee didn't even prove a case of entitlement to their negligence in 200 claim. They never provided any proof in the first instance of when they last inspected the area. So with these questions of fact, it simply was error for the court to grant the contractual indemnity claim. And unless you have any other questions for me.
No, your appeal is fairly narrow. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff, respondent, appellant. With respect to the appellant's position on 1.7D, the trial court granted a summary judgment. As a respondent, I'd just like to say that this court should affirm and that all the elements on 241.6 have been met. Slippery condition, ice on the barge. It was a walkway. This was the only sole means to get to and from ingress and egress.
You want to turn to the 240 claim?
Sure. I'll take my 240 claim. On 240, it's our position that the trial court erred because under Runner, the plaintiff's injuries were a direct consequence of elevation-related risk as a result of failing to provide an adequate safety device, namely the gangway. My adversaries focus on the ice, and as this court knows, you could have ice and you can have an elevation-related risk in the same sentence, in the same case, and have summary judgment to 240. That's in Kafisi and Havorka and all
You
this.
cite a case called Pipia, which I think is quite apropos.
Yes.
You want to talk about Pipia?
Yeah, sure. This is exactly like Pipia. So in Pipia, the plaintiff was on a floating barge or raft, and the wave came, it moved the platform, and he grabbed something to prevent him from falling. It was unsuccessful, and then he hit the barge and slipped and tripped. So this is exactly like Pipia. Here, the key thing to focus on is that when his right foot stepped over and slipped, it was his left leg and the rest of his body that was going down, this is at 399 to 400, and was going down in between the two barges and was going to fall 8 feet to the freezing cold water below. And as Mr. Sanchez, who's an employee of TDC, says, he would have died and been crushed. So that's where his injuries arose, because as he was falling back, he grabbed on to Mr. Sanchez, who was in front of him, and grabbed his backpack, and he was pulled up. At that moment, as he was trying to prevent and brace himself from falling, he was injured. And as we know under Striegel and all sorts of cases in this department, you don't have to hit the ground and fall to have 240 subsection 1, especially a recent case, Lindsay against G.C. Maiden in this court. A plaintiff was injured while arresting himself from falling. So this is on par with Pipia. It's also on par with Sunin, which is another case that this court cited Pipia, where it actually analogized the plaintiff in actually I'm saying that. I have it in my brief. In Sunin, the plaintiff's leg went into soil that was part of an excavation that was, improperly backfilled, and there'd been raining 3 days before, and his foot and leg went under to his knee or to his thigh. And this court analogized his elevation-related risks to be like Pipia. Specifically, this court actually said the following. It said, the elevation differential between the ground level and the lower level to which plaintiff's foot and leg sank is analogous to the risk that a worker standing on a platform on a body of water would fall into the water, which we have found to be covered by Labor Law 240C Pipia. One last thing, because my light is on, although I could save it for reply. I could save it for
Well, the red light is when you have to stop talking. You can keep
Okay,
going.
fine. I understand. I know. I've been here long enough to know what this is. But I may go over. So what I wanted to say was, in opposition, there's no evidence that he was recalcitrant or sole proximate cause. To the extent that my adversaries argue that, well, the direction was that, or it was a standing order that he was not supposed to cross the barge without a gangway, as you know, under Gallagher, against, New York Post and all of your decisions, the standing order is not sufficient to forestall summary judgment. He was never given the gangway because there wasn't one there. It's undisputed. He was never given the gangway that he refused, so that's not recalcitrance under Bianconetto. And he was never told, wait, don't cross, wait for that gangway. And we also know under Blake and its progeny that he can't be the sole proximate cause when there's a statutory violation. So it's our position that summary judgment was erroneously denied to plaintiff under PIPIA and under all the other cases cited by this court. And I think, one other thing I'd like to address, if I have a chance now, is that this case is really distinguishable from Nicoretti and Serrano. What's interesting in Serrano, which the defendant relies on, this court specifically said the following, which makes this case all the more appropriate for summary judgment. This court said in Serrano against Consolidated Edison, 146 AD 3rd 405, it's in my brief, plaintiff did not point to any evidence that he was injured as a result of any attempts to avoid falling off the scaffold, which is actually what this case is. He actually was injured, preventing himself from falling 8 to 12 feet below as a result of the failure of the defendants to provide a safety device, which, by the way, was in derogation of their own safety plan, which I can get to on
Thank you. You have time in rebuttal.
Thank you.
Good afternoon, Your Honors. I'm Judy Shamatzi with Wilson Alster for Tappan Zee. I would like to start with the contractual issue for no other reason that it's shorter, only to say that the cases on which the appellant relies all involve contractual language that is different from the language at issue here. So the conditional grant of summary judgment on this contract, which is broad and includes that gray zone where it could be nobody's fault, is entirely proper. And on the condition that we will leave for another day the determination of what percentage of fault there may have been and to what degree the indemnity may have been liable. That said, I do believe that grant of summary judgment to Tappan Zee is entirely appropriate. First of all, this is not a 240 case in that it does not involve an elevation-related
Well, what
risk.
about the distance between where he was stepping and the water below, which was 8 feet below? Why isn't that elevation? It's like stepping between two ladders that's above, 8 feet above the ground, except it wasn't ground, it was freezing water.
Well,
why isn't that elevation?
But because where he is stepping, it is easy. It's two
stepping
planks
from one
that are
barge
close
to
enough
the other,
together
and if he
to walk.
doesn't make the step successfully, he will fall 8 feet into the frigid water.
But it is a place where you can just walk across. The reason he's falling is not because gravity is pulling him down. The reason he's falling is because, or he claims to have fallen, is because he thinks there may have been ice, although he didn't see the ice before or after, and says that he just slipped. So
whether there's ice or not, gravity would still be pulling him down towards the water.
But he's falling in the same way that he would be falling if he were walking on solid ground anywhere else. He's falling because of the ice. He's not falling because there's an elevation. He is
Counsel, this is
falling
why
on
you
the
didn't
ice.
you didn't try to grapple with PIPIA in your reply, and I think that was a mistake because PIPIA says we found there was a 240. We found for summary judgment 240 because he was, quote, the plaintiff fell while struggling to avoid the elevation related risk of falling into the water. And that was between two barges. I mean, you can't just ignore that case. You got to try to grapple with it.
I do believe, Your Honor, that there's a distinction between what happened in PIPIA, as I understand it, is that there were these makeshift stepping stones basically created out of wooden planks. What you have here are actual walking surfaces of put next to each other across which you can walk.
Well, no, it wasn't walking surfaces next to each other. It was walking surfaces several feet apart.
They were not so far apart that you can't walk between them if you take a
It's 2 to
step.
3 feet apart, depending on where the waves moves the barges.
Right.
So that's not like walking surfaces. It's not like adjacent paving stones. It's a good distance that one has to step over.
Well, well, again, there's nobody has any difficulty walking from one to the other except when the plaintiff loses his footing, and he
But there
claims
should
that
have
it
been
was.
a gangway there.
There could have been, and arguably everybody would have been safer if there would have been, but that's not to say that he fell because of an elevation-related risk. He says he fell because he thinks there may have been ice, although he didn't see it before or after.
Wasn't it your client's obligation to put down the gangway?
So, Your Honor, it was, apparently the safety plan called for that to be there.
That's what I meant when I said your client's obligation, under your own safety plan.
Your Honor, there was not one, but on the other hand, it was not necessary for that to be there because the plaintiff did not fall because of the absence of that. He fell, he says, because he slipped.
He slipped because of the ice, but why isn't this a combination of things that there's no gangway and he's taking this big step from one barge to the other barge, and then he slips on the ice. So the absence of a gangway is not the sole proximate cause of his accident, but it is a contributing cause of it.
I'm not really sure why that would be true, Your Honor. If there had been, the ice would have been on there. He's saying he fell on ice that he didn't see. But if there had been a gangway, the ice would have been on the gangway, right? So the ice, gangway one way or the other doesn't change the reality that the reason he's falling.
Well, if there was ice in the gangway, that would be a separate violation, wouldn't it?
Well, if there had been any ice, and again, nobody saw it before and after, and there's testimony that they've been good with the salting. But
Gangways usually have railings on the side. It's a very different thing, isn't it?
well, it doesn't say it can't get icy, right? So if you're walking from point A to point B on a level, to the same elevation, whether you're walking on the gangway or you're taking your step from one area to the other with a gap in between, it doesn't make a difference as far as why you're falling. If you're falling because you're losing your footing because there is ice, you are going to take that step.
But if you're on a gangway and there are railings, you don't fall into the water.
Well, he didn't fall into the water.
Well, only because of the good fortune that Mr. Sanchez was in front of him.
But again, he wasn't falling because of an elevation-related risk.
Thank you, counsel. You have time in rebuttal. LB.
Your Honors, I'll be brief. The statement or the argument that was made with regard to the contractual language was addressed squarely in our reply brief, where we cited the language in Scott and we cited the language in Spielman, and we pulled the appellate briefs and made reference to them so that you could see that the contractual indemnity language here and the contractual indemnity language in Spielman and Scott are equally broad. There is only allowed to be conditional order of indemnity in very limited circumstances. In each of those circumstances, it has to start off with the fact that the the party seeking indemnity is free from negligence. There may be issues later on as to whether or not the indemnity clause is triggered. Does it arise out of? Is there negligence? But the starting point for conditional indemnity has to be, is the person seeking indemnity free from negligence? There are certainly questions here, questions of the gangway, questions as to the salting, why their laborers were not there at first light to make this area safe. And accordingly, we would ask that the court modify and deny that portion of the motion.
Thank you, counsel.
I just want to read you the testimony from plaintiff that supports 240 violation. It's 399 to 400. He says his right foot steps over, places it on the ice, it slips. Then what happens? Well, when you say your body went down, where did it go down? It started to go down between the barges, carrying over to 400. It started to go down towards the water. My body started down towards the water. Did it go down into the water? No. How do you stop it from going down? The gentleman in front of me, I had to grab onto the gentleman in front of me and his backpack with my right hand. So that establishes the fact that this was proximally caused by an elevation-related, gravity-related risk of falling 8 to 12.
A combination of factors,
Well, that's correct, which this court has upheld.
Good enough for your position.
It is. And with regard to PIPIA, you can't avoid PIPIA. It's just, it's there. And it's good law because it was cited subsequently in 2020 by Sunin, which is in my brief and I discussed. So PIPIA is indistinguishable. And interestingly, in PIPIA, you know, specifically, if you look at the trial court decisions, because it's not borne out in this court's decision, he grabbed the pipe hanger above him to keep it from falling. And that's, I think, where this court focused in to say it was an elevation-related risk, because that is exactly what happened in our case. With respect to the gangway, it's really significant. At 1224 of the record, this is what TZC's safety plan states. It states a lot, but this is what's really relevant. Gangways are to be utilized as access from one vessel to another when two or more vessels or other barges are lying abreast, which is exactly this case. And if you look at 1261 of the record, it's a good photograph, which is authenticated by the plaintiff because he took it later that day. And it shows the barges, it shows them tied up together, and it shows the elevation differential into the water. I mean, it just really speaks, it just tells the story. If you have no other questions on 200, I'll rest on my brief. Thank you very much.
So with respect to the contract and the way to properly analyze the language, because this particular contract specifically says that it will include claims and damages arising from non-delegable duties, and because it specifically promises indemnification for anything arising out of, irrespective of the company's, of either indemnitor or indemnity's negligence, the proper place to start the analysis is not, as counsel suggests, the potential liability or the potential negligence of the indemnitor, but rather whether this language is triggered, and it absolutely is. So then becomes the question, okay, you have triggered your indemnification language. How much indemnification you're going to get is going to depend on whether to what degree your own negligence is going to be borne out by the facts. But there's no question that this indemnification clause is triggered, and that is why conditional indemnification under the contract is entirely appropriate and in fact necessary. With respect to the 240, I can only reiterate that what we're talking about here is walking from one surface that is level with another surface, where the claim is that the plaintiff fell because of ice, although we do dispute that, seeing as how nobody saw the ice before or after the fall.
But your own safety plan uses the word barges.
It does.
You need a gangway whenever they're going to cross from one barge to another.
There's no question that there was contemplation of a gangway being there, but the reality is that is not. If the plaintiff is right that he slipped on ice, even if he's not right, more likely since the ice wasn't there before or after, that he simply slipped because he lost his footing. It's not because he's at a height from the water. He's not going. He's stepping across a gap.
But if he falls, he falls into the water. At that point, if he falls into the water, which it has a height of between 8 and 12 feet. So that's the height differential from the barge to the water. That's why you require in your own safety plan that there be a gangway.
I do understand it does require that, Your Honor, but again, that is not the cause of his fall.
Thank you very much, counsel. Thank you all.
Thank you.
Okay. Xerox Corporation versus Travelers Casualty.
Good afternoon, Your Honors. My name is Ron Schiller. I represent Travelers. And I'm going to be talking, as Your Honors know, there are cross appeals here. I'm going to be talking about the language of the contract and want to focus the court's attention on a couple basic facts that the court knows from other cases. This is a contract construction case, and even though there's been a lot of briefing, in the end, the court is being asked to construe the language of the prior act's exclusion, which is a 6-line exclusion in a policy that was negotiated between two of the most sophisticated businesses in the world. There is no allegation in this case that it is ambiguous. There is no attempt to run away from that language except to the extent, and I'm going to talk about it for a minute, except to the extent that Xerox is citing cases that don't deal with the language they agreed to in the prior acts exclusion. There are 2 cases directly on point with a prior acts exclusion and a subsequent acts exclusion that has language materially the same as ours, and both of them upheld the exclusions. Neither of them found that they were in any manner ambiguous. Neither of them found that they had to apply a proximate cause type test, which is essentially what Xerox is arguing for here.
They're arguing for but-for, which is the correct, I believe, the correct standard, is it not?
But-for is the correct standard for at least part of this exclusion. I assume, by the way, that all the members of the court have the actual exclusion, which is from record 3432 in front of you. But
you can count on it, counsel.
Okay. They're relying on the but-for exclusion, and as Your Honors has in front of you, the prior acts exclusion says it is agreed that no coverage will be available under this policy for loss on account of any claim or related claims based upon, arising from, or in consequence of. And it's the but-for exclusion has been derived from the based upon, arising from, or in consequence of. And this court's dealt with it as recently as WDF last year. 2 of the members of this panel were on that and said that that but-for cause can mean nothing more than having some connection to or in connection with. And Your Honors, the reason I emphasize this is if you look at the case that they rely on, Mount Vernon was the first one, that dealt with based upon or arising from an assault and battery exclusion. And the court said the unremarkable thing that if there's assault and battery, it's excluded. But if there's a claim that could exist but for assault and battery, then if there's no claim that could exist, then you apply the exclusion. That's not what our exclusion says.
Did Countrywide make that same distinction that it only applied to battery cases?
What they did is they applied it to the legal claim, Your Honor, as opposed, I'm sorry, the assault and battery one, the Mount Vernon one I said, was applying it to the legal.
I'm talking about Countrywide.
Yeah.
Which is more general language.
Countrywide did not involve our language, Your Honor, and that's where I was going, is that ours goes on to say, in consequence of any fact, circumstance, or wrongful act committed, allegedly committed, or attempted, in whole or in part, prior to January 1, 2017. None of the but-for cases that I agree deal with the first part, which is the based upon or arising out of, but they go on to talk about a legal claim or a wrongful act. Ours has fact, circumstance, or wrongful act, and no case has said that you don't enforce those terms, and in fact, the case law that we've cited to the court, and especially WDF and Champlain, which actually deal with those terms, deal with the following terms, say you do apply all the terms. It goes on to say any fact, circumstance, or wrongful act committed, allegedly committed or attempted, in whole or in part, prior to January 1, 2017. And Your Honor,
Counsel, I mean, what we're talking about here is would the decent litigation have gone forward without the excluded pre-2017 wrongful acts?
Not on the record and not on the facts, Your Honor. It could not have. Here's why.
Do we give any credence to what Mr. Deason said about that?
Yeah, we do, but we give credence to his multiple complaints.
What about his other statements, DeHorace's complaints, where he said, no, I wouldn't have done it?
Oh, no. In his, I'm sorry. Are you citing his complaints? Because the only time Mr. Deason ever said, I would have brought this, even apart from what happened before January 1st, 2017, was in his after-the-fact affidavit, and it directly contradicted what he said in sworn testimony.
We put a lot of things in complaints to make the other side look bad, and that seems to me what he was talking about with respect to the pre-2017 behavior of
That's not
Xerox.
what he said, Your Honor. With all due respect, what he said, Your Honor, was, I brought this suit because I was shocked to learn that from 1999, 2001, 2003, 2006, and never disclosed in any of their public filings, Xerox entered into these agreements, the joint venture agreement and other agreements with Fuji, kept it a secret from us, had an obligation to disclose it, and when they get, Your Honor, to what happened after January 1, 2017, it's a continuation of that concealment is what he's saying. The concealment and the deal rights, the price that he said Xerox was forced to agree to with Fuji because the value of its so-called crown jewel rights had been irreparably compromised, solely tied to everything he said in Decent 1 and in his testimony, which we've cited to Your Honor. It's
Decent, you would concede that Decent 2 is just about whether or not he could get the vote in, right? So it doesn't matter about the pre-2017 behavior.
It's also an attack on the board for being conflicted and Mr. Jacobson for being conflicted because they hadn't disclosed these bad deals. And to be
So this
clear,
is the original sin, that everything they did after that was colored by that.
I mean, I know Xerox likes to made a joke that this all goes back on a but-for basis if you go that far to Mr. Deason's birth, but that's not what the undisputed pleadings are in this case. That's not what the settlement agreement says, and that's important, Your Honor. Their settlement agreement actually gets a release for every single agreement that they agreed to and for claims that arose from them. What Mr. Deason said is, I've been a shareholder for 10 years, and how dare you not disclose to me that you would agree to this and continue to agree to this? Your Honor, the things that they complained about in Decent 2, in the Decent amended complaints, are failures to disclose and self-interest that resulted in this bad deal that tied directly back to 20 years of bad deals, Your Honor. I respectfully suggest that the actual record, and there is nothing that contradicts it, except for Mr. Deason's self-serving affidavit directly contradicting what he said in sworn testimony in the underlying case when I wasn't even taking his
Counsel, let me just switch gears for a moment. You have so many affirmative defenses, and it seems to me in your reply brief that you're standing by all of them. Is that correct? What has latches got to do with this, for
we
example?
reserved rights. We reserved rights, Your Honor, in the event that we had to go.
Is there any? Are there any affirmative defenses that you would debride from your answer now, or are they all you're standing by all?
No, Your Honor, I agree with you that it does not appear that we would have to assert latches. But I would also point out to the court that at this point, none of the cases before the court involve a trial. As Your Honor knows, they all involve construction of a contract, and they all involve construction of language like this, and as applied to a closed record. And the record is closed. They settled all, or ended all of the underlying cases. And what you have to rely on, Your Honor, is not Mr. Deason's self-serving after-the-fact affidavit that contradicts everything he said in sworn testimony that I didn't take, but the parties agreed we could use as if it were taken in this case. So it's good testimony. But he said, I brought the suit because of the lies and deception. And I do, because I don't want to mislead the court, I do want to briefly address the misrepresentation claim, but I'll save it for rebuttal if that's
Save it for rebuttal. Thank you, Counsel.
okay.
Good afternoon. Tony Tatum here on behalf of Plaintiff Xerox, the respondent and cross appellant. I'll just start out briefly by saying the record stands for itself. Mr. Deason's testimony is not as characterized by my counsel here, and so it will stand for itself.
Counsel,
I do want to get into
Counsel,
some. Yes, Your Honor.
Judge Mendez here. The lies and deception that counsel was alluding to, is that reference to the agreement before 2017, or does that have to do with the transaction to sell Fuji, Xerox to Fuji without looking into the true value of the corporation at the time of the transaction?
Your Honor, that's a great question. It all has to do with disclosure of whether or not the crown jewel lockup even exists. So I think as Your Honor mentioned a few minutes ago, yes, Mr. Deason was hot under the collar. And we're not here to say that there's no reference in the complaint about the crown jewel lockup. It's a fact. It's a provision that's contained in a joint venture agreement back in 2010. But if you look through, Travelers has cited two allegations out of over 200 in the complaint, other than this, generalized statement that there was 17 years of non-disclosure. Who did Mr. Deason sue? Mr. Deason sued only directors who approved the transaction. He could have sued earlier
Suppose he might have had statute of limitations issues against some of the others, right?
Maybe he could have.
Now, he also brought a common law fraud claim, right?
He did.
Deason won. Now, what inference should we draw from that? Doesn't that claim refer to damages that were pre-2017?
No, it doesn't, and there are a couple reasons why. Again, if you look at the complaint, a couple reasons. You look at the complaint, you have to look at the acts that are giving rise to. It's not only the but-for test and whether or not there are the excluded conduct is essentially the gravamen for the complaint. That's not the case. The key piece on Your Honor, on the fraud is there is a fraud count, and there's no question about that. But in the order, the preliminary injunction order, the court itself, Justice Ostrager, looked at all the facts, and this is after all the, a lot of discovery over a very condensed period between April and May. He said the linchpin of this action is conduct, and it really was of Jeff Jacobson and the board between March of 2017 and the announcement of the proposed merger in January of 2018. Your Honor, in that case, there's a footnote. We can look at the order itself. The court didn't even consider the fraud claim at all. So if you get to the other piece of the prior wrongful acts, which is loss on account of, what my colleague didn't tell you is in settling this case, there's unrebutted testimony, not only for Mr. Deason, and I submit that his testimony and his affidavit is completely consistent with his deposition testimony. You can read his deposition testimony and just hear the anger he has for the board that approved this transaction. But there's testimony, unrebutted, again, there's not a shred of evidence from Travelers that the purpose of the settlement, which happened days after this injunctive order, was to get rid of the proposed transaction, to avoid a proxy fight, and to get rid of the breach of fiduciary duty claims. You've got an injunctive order where the court, Ostrager couldn't have been any clearer. I have not considered the fraud allegations in connection with this order. So there's a $28.5 million settlement that was paid, and there's no evidence before this court that that loss had anything to do with this generalized allegation of the existence. It's not even a wrongful act.
Now, a separate issue, of course, is the reasonableness of the settlement, and Justice Ostrager found that that's almost always a jury question.
We would
you
agree.
have to concede that, right?
We would agree. We think that that is a fact issue. One thing, too, and not that the court's not completely
One of the
familiar.
arguments you make, is it not, that Travelers is slow in coming up with this reason for not paying? They don't announce it until January 2019, right?
Yes, Your Honor.
And their own internal emails recognize that they have difficult defenses. Is their answer to that perhaps that, well, they didn't know about it?
That's not the case. I mean, you are exactly right, and this is why Justice Ostrager, there's a high standard in New York for bad faith, but he denied their motion for summary judgment. In short order, what happened, this all did happen in a very tight time period, but you got Chubb is the largest property and casualty insurer in the world. It paid $15 million. It didn't think that this action arose out of the crown jewel lockup.
Chubb and XL decide to pay, you would normally have expected that Travelers would follow along.
You would normally think so, and Travelers sat on its hand. It did have this email traffic. You've seen it. Gosh, this is a really weak defense. Well, what do they do from April until January? They
Counsel,
sit.
they're not bound by what Chubb and what Excel did, right?
They're not bound, but they do owe their insured an obligation to be on equal footing, and they didn't do that. They let Chubb pay, they let Excel pay, and they didn't tell Xerox until January of 2019. And if they really thought that the underlying lawsuit and the related lawsuits arose out of the Crown Jewel lockups, they were
When did they
duty
become
bound.
aware of the Crown Jewel lockups?
Pardon me?
When did they become aware of the Crown Jewel lockups?
They knew of it in April and May. They contend that they didn't have an obligation to disclose until there was a payment made by Chubb and Excel. But they knew about this potential defense no later than late April or early May. And if they had advised Xerox at that time, which they were duty bound to do, what would have happened in normal insurance coverage cases? Xerox had what's called continuity of coverage. It had coverage from 1994 forward from this insurer and others. There was a spinoff in 2017 of Conduit. So Xerox spun off that entity, so it had a runoff policy. This is not a case about whether or not there's substantive coverage. The wrongful acts is nothing but a gating mechanism to either send this claim to the 2018 policy or the runoff policy. Chubb did its analysis. It thought it belonged under the 2018. Excel did too. So what did this insurer do but sat on its hands and didn't raise it? But this is not a case where there's going to be no coverage. We gave sufficient notice under both the runoff and the 2018 policy, and if we're not going to be paid under the 18, then Travelers is going to owe it under the runoff. Thank you.
Thank you. First, you want to talk about the runoff policy for a moment? We haven't really gotten to that.
Yes, because that was interesting. We hear about continuity of coverage and a gating mechanism. Again, we're controlled by the language that Xerox, Marsh, its other brokers, its lawyers.
I mean, was there adequate notice in the first place for the second policy, for the earlier policy? How was the notice for that?
No, they gave us letters that specifically identified the policy they were relying on.
And then they had some catch-all language, but
catch-all that says, and any other policies that may apply.
And that's not good enough.
But no, not under New York law. Secondly, and by the way, they cited Section 3420, which is the bodily injury, personal injury statute that requires you to give notice in 30 days. Doesn't apply here. And when we said that in our brief, they didn't touch it in reply because it doesn't apply. It's a waiver or estoppel standard. To be clear, New York law says that an excess insurer is not required to give notice at a specific time or not. It's supposed to give notice when it's reasonable. We didn't learn that Chubb paid until the end of October 2018. We didn't learn that Excel agreed to pay until November. We weren't asked to give a coverage decision until after we learned that Excel agreed to pay, and in short order, we did so in January. After giving our coverage opinion, they executed an agreement with Excel. They then sued us. They never said, because of you, we didn't make a claim under the runoff policy. They could have made a claim. In fact, they could have made a claim. The runoff policy existed until January 1, 2023. You want to know why they didn't make a claim? $10 million retention, as opposed to the $2.5 million deductible or retention here. Secondly, and they have a problem here, they didn't bargain for continuity of coverage. They actually, in the Excel language, which we follow Form 2, decided not to take the straddle coverage that the primary through Chubb gave them, but actually have a very broad subsequent acts exclusion that wouldn't give them any coverage here. But if they had, then why didn't they amend to bring the claim here? And when I said to your honors, I just wanted to touch on the misrepresentation claim, it's because they added that at the end of discovery. And to be clear, Justice Ostrager just let everything in. And to be clear, he was also reversed on his decision on the transaction in the underlying case. But on their misrepresentation claim, it's not even clear what they're asking for. It certainly doesn't apply where there's no fiduciary
That's the
duty.
third cause.
You didn't really make a misrepresentation. You just didn't say anything, basically, until you denied it.
That's exactly right, Your Honor, and that's exactly what the law provides, and they have no damages as a result of it, as we cited to Your Honor. It's a lot of sound and fury, but the reality is, and I'm out of time, so I just leave you with this thought. It is absolutely incredible to say that Mr. Deason and the other and the other plaintiffs, but Mr. Deason is the one who we've both trumpeted in all of the briefing, did not say he was outraged and that the reason he brought this suit was because of hiding that Xerox's entire value for the Asian market was substantially compromised by a secret deal that was not disclosed in violation of federal law. They should have filed various disclosures through the years, and he actually said that was a reason he instituted suit against Xerox and its directors, Record 2803. He further testified he was, quote, irate about the joint venture agreement and shocked that a board of directors of a public company could hide this material of a fact from their shareholders for 17 plus years and not disclose it, and such a material fact that you could not sell the company for any value.
Counsel,
That's
your
what-
papers unwrap that very well. Thank you very much.
Your Honors.
I'm going to start off briefly, and thank you for your patience, with the negligent omission and no damages. That's frankly just spurious and ridiculous. If Travelers succeeds on its belated argument and secret hiding of a defense, the obvious damages in relying on the lack of this transparency with its insured is that we could be out of $15 million in coverage. And not only $15 million, but there's excess insurance above that to the tune of $17 million more. So what Travelers did is essentially create a $32 million loss for Xerox. There are two other insurers. They're not involved in this suit because we hadn't gotten through the Travelers layer. But there's 30, Your Honor, you look confused. There's
why is it 32? Because you got 30K from the, 30 mil from the other two insurers. So what we're talking about now are defense costs that you incurred, which I'm sure were substantial, but does that even crack the first 15?
It does, Your Honor, and this is in our briefing. And those two are not, it is Hartford and HCC. So one of those owes $15 million. They're sitting and waiting to see what Travelers does. They're not doing anything because Travelers hasn't paid its limits. But this has huge damage repercussions for Xerox. I want to go back. Yes, Your Honor?
$32 million would be paid by Travelers, but that Travelers, by denying the $15 million, is causing other things to occur?
Yes, ma'am. Yes, Your Honor. That's the other two are just sitting and waiting and saying the limits aren't exhausted. I want to go back just briefly because counsel has really tried to confuse the court. The but-for test in this state is quite clear. As Your Honors know, in McGraw-Hill very recently, there was a contract claim. There was a licensing agreement at issue, but that was for a copyright action. I think the court correctly reversed Justice Ostrager in that case and said that the contract or the copyright action claims could stand on their own. What the only real difference in this, in the exclusion, is the words in whole or in part. And WDF and Champlain, which are the only two cases out of scores of First Department and Court of Appeals cases, they have this in whole or in part. In WDF, it was admitted by the insured that there were 19 false filings, so they were essentially the wrongful conduct was admitted. The court didn't even engage in any real analysis. In Champlain, there was one cause of action out of three, and the court didn't look at it in whole or in part as to whether or not the but-for cause test had been met. It looked at it as part of allocation. Should we allocate part of this loss? And the court found on the this third claim, they applied a gravamen test to figure out whether or not that count really related to the excluded time period. The court found it did, but that's the only application that the court used the in whole or in part language for.
Thank you, counsel. Thank you.
Thank
both.
you, Your Honor.
Members of the panel, may I address in 60 seconds one consequential damage issue that counsel said?
The answer is no.
Claim wrong.
Thank you, counsel.
Okay. Thank you very much.
You're welcome. Tavor versus 391 Broadway.
Good afternoon, Your Honors. May it please the court, my name is Warren Dank. I represent the appellant plaintiff in this appeal. There are several issues that we are appealing from in regards to the reversible errors made by the lower court after trial. Specifically, all of the causes of action in the complaint was dismissed after trial. There was a breach of contract action.
Plaintiff, just, wasn't it your burden, sir, counsel, to show what the net profits were rather than just sort of pick something out of a hat? I mean, didn't you have to get into the weeds a little bit and say, this is what the books and records show, and this is what should have been distributed to the partners from sales of the relevant properties? And did you do that?
Okay. Let me, there are several causes of action of breach of contract. You have several things going on. What you're referencing, Your Honor, has to do with K1s.
Right.
Okay. As far as K1s are concerned, there were two K1s. One was issued by 391 Broadway to the plaintiff, and then there was one with 225 85th Street.
Right.
The K1s were issued 4%, 5% partnership interest. We deposed the defendant at the time. We established at the deposition, it was unequivocal. We cited to it in the brief. The deposition transcript as to the K1s. Defendant's own testimony established that $250,000 or the profits of 225 East 85th Street was sold with a $2 to $3 million profit. That's his own testimony. Now, if his own testimony...
Not very exact, though.
Right, but he stated at a deposition that they made $2 to $3 million.
Right, so that's, yeah.
So we're assuming that that is a party admission. He admitted what they made. So the burden has already been proven from the plaintiff's perspective in terms of the equitable or the profit share of what plaintiff should have received, which is $250,000 on the 225 K1. On the 391 K1, he should have received $200,000. But yet, I have the court look at the transcript of the deposition, which erroneously the trial court didn't even consider. Under CPR 3117, she didn't even allow any of the transcript to be admitted into evidence or read into evidence. And as this court is completely aware, the standard to allow the depositions to be used into transcript for any purpose, but what the timing of the deposition testimony should be considered by the lower court, not the exclusion. Now, getting back to the original breach of contract, you have contracts here. You have a $300,000 contract. The $300,000 contract.
Which one are you referring to when you say the three? What's the date of that one?
November 15th, 2000.
That's your stronger argument. I don't think you really had a contract, personally, from in the October emails. I don't think that created a contract, frankly. But why don't you go on with the November contract?
Oh, yeah, okay. I'll address that do you want me to address the October?
No, go with November. It's your stronger argument, I think, so.
Okay. The November contract's very clear, okay? We at trial tried to admit the contract, and there were issues that were raised by the lower court.
Explain where the original was or may be?
So, I'm sorry?
Did you explain where the original is or may be?
There was never an original contract. There was email correspondences between attorneys. There was an attachment to the email that had the contract. The email was printed out at the time, okay? And then there was handwritten comments by Gil Buzadon, who made the comments or handwritten changes. Now, what's pretty, I guess you can draw a very clear inference here that at the deposition of Gil Buzadon, which I cite to in the brief completely, he admits he signed the agreement. He admits there's an agreement. He never denies this. He
Should
doesn't
we,
even testify
but should we be
to that
concerned,
fact.
counsel, should we be concerned that that handwriting that you just referred to is it does not, it's cut off on the copy that was admitted or not admitted at trial, but that was offered at trial? Should we be concerned about that? I mean, that there's some emendation in handwriting, we don't know what it is, so should we say, we don't know if there's a contract because we don't know what that writing says?
No, Your Honor, and I'll tell you why. That is collateral, doesn't go to the issue. The issue is very clear. $300,000 was supposed to be paid to him for services rendered, okay? Very clear.
Is there a calculation of interest on top
Yes,
of that? That you were
9%.
claiming? And so what is the total amount?
$467,000, okay? All of this, by the way, was testified to, admitted, party admission, under Gil Buzadon. Now, if the court had a problem with the copy under the best evidence rule, then under a party admission, it should have came in. Under the business record exception, it should have came in. It didn't come in at all. But yet the court admits the October email contract, which, Your Honor, I would like to address. I believe the email contract of October is agreement based on the case law and based on the party admission. Again, all of the testimony of Gil Buzadon at the deposition.
I don't think you got an admission out of him. I think he said that this October agreement lasted until the November agreement. That's what I think. I think you asked him at the EBT questions about what does this say, and he read it. He said, this is what it says. But I don't think he was affirmatively signing on to saying that I agreed to that and that it was a contract that continued past the first month. You can,
Yes,
why don't you think about that and you can address it on rebuttal, like why
Okay, no
his
problem.
statements do.
Now, Your Honor, I'd like to address one other thing.
You can do that on rebuttal too.
No problem, Your Honor. Thank you.
Okay, counsel.
May it please the court, I'm Bruce Johnson. I represent the respondents in this case.
Now, counsel, what do you think about not letting in the deposition under CPR 311-7A2, used for all purposes?
The trial court made clear that she actually read the transcripts portions that appellant asked her to admit into evidence, and that she had reviewed them, as I said.
So she said it was irrelevant?
No, she said that they raised more questions than they answered. In other words, they were equivocal. They had no sufficient probative value.
Didn't it come in and then let the trier of fact sift it? I guess she was a trier of fact, so sort of preemptively she's making a finding of fact without it being in evidence? Was that what happened?
Essentially, that's what she did.
But doesn't that simply deny us the right to look at it as opposed to letting it in and then we can evaluate how it should be treated?
Well, essentially, as the trier of fact, she reviewed the documents and came to a conclusion that they had no probative value or insufficient probative value. So ultimately, the court did review them and did make a decision as to their evidentiary value. And what they were trying to be used for was to get the judge to reverse her decision not to admit 3 of the proposed exhibits, or proffered exhibits.
So, counsel is trying to admit a contract that's dated November 30th, 2015, and checks that were written out to his client that were returned because the account had been closed. And so, looking at the record at page 418 and 419, your client, the defendant, is asked, you see that it's, and this is at line 20 on record 418, you see that it's check 151 and 152. You issued these 2 checks, right? Yes, I did. And then continues, that's pursuant to the agreement that we referenced back on November 30th, 2015, right? Answer, yes. What is equivocal about that? So he admits that he had a contract and that he wrote 2 checks, and I'm not even going into the other stuff he said, that the checks were returned, not because the account was closed, but because maybe they had insufficient funds. He goes into all of that. I'm wondering what is equivocal about any of that?
That wasn't the only reason that those, the deposition transcript portions were being offered. There
I
were other-
understand, but as to that point,
As to
which
that
goes
point-
to the, it's a central issue in the case.
As to that point, Your Honor, the plaintiff appellant deposited those checks on dates when he was not entitled to deposit them, according to the agreement. Those checks were not a contract of any sort. Those checks were simply as essentially security in the event that the LLC did not.
They were given to him pursuant to the contract. That was part of the agreement that they had.
There was a
And
contract.
he was going to hold on to these checks for 90 days.
And then replace them.
And then replace them, but if the checks were not replaced after the 90 days, then he could deposit them. And if,
But the 90 days had not come about. The date by which he could deposit them had not come about.
in
That
any
was the
event,
problem.
there was a $300,000, there was an agreement that your client was going to pay the plaintiff $300,000 that at the end of the day, he never got,
There were various agreements.
plus interest,
Pardon me?
plus interest if the money wasn't paid by a
There was-
certain date.
There was interest, but the actual rate of interest was not specified in the document at 374 of the record. The problem, the biggest problem was the best evidence rule, that there were a number of handwritten interlineations on the document that was offered at trial, which was different than the document that was used during the deposition.
The body of
which
the
were not
agreement was,
readable.
the body of the agreement was one and the same. There was no crossing out, was there?
No, there were, on page 374, where it mentions that a final date of, I think it's August 18th of 2018 or 17, there are 2 symbols that indicate that there are handwritten alterations or modifications or additions to the contract. Those refer to what is on the left margin that is partially cut off and unreadable. So the total substance of the contract is not determinable from the document that was offered at trial, which, by the way, is different than the document that was used during Mr. Busidon's deposition. So we don't know what the final agreement of the parties was, and Mr. Busidon said there was an agreement, but it was not this document.
Thank you, counsel.
Thank you.
Okay, I'd like to address the unjust enrichment claim, okay? And that, to me, is pretty telling in and of itself, in that the trial court completely changed the cause of action and conformed the pleadings to the proof of trial, turning a cause of action from unjust enrichment, which has a different evidentiary establishment, versus a quantum merit, okay? The thing that is troubling is I tried the case. I tried every way, shape, or form to get the agreement in evidence, both getting all of the documents, even bounced checks as party admissions, and they would not be admitted into evidence for whatever reason. Then I turned around and tried to get the court to conform the pleadings to proof to say there was a contract implied, and she says, no, you can't bring that in because it wasn't part of the record. But yet the court is allowed to change sua sponte, a cause of action, making different evidentiary.
Counsel, all of this doesn't matter if you in fact had a contract.
That's correct, but I'm only saying that if the court was to buy what the trial court found, that there was there was a lack of foundation. The fact is, the deposition testimony is a party admission. The fact is, and Your Honor made a very good point, The deposition transcript should be brought in and then weigh the evidence. Weigh it. She decided unilaterally, I'm not bringing this contract in. And the proof is in the trial transcript. I tried laying foundation, it was rejected. I tried a business records exception, I was told I have to bring AOL in. I tried a party admission, in which, by the way, the trial court uploaded and e-filed a copy of the transcript of the excerpts, the sections. She said, send it to your adversary, I'm going to admit it. She turns around that morning and says, no, I'm not admitting any of it. You could have called the witness in. Very good. So you're rewriting.
Counsel, you did recite all these steps in your papers, so we know that this all.
I'm sorry?
You already recited in your papers the steps that you just told us
Yes,
about.
I did.
So I don't think it's necessary to go on about
Okay.
that.
And as far as what my adversary is going, what's also an inference in what's telling, the deposition transcript and the party admission stuff, they didn't even put a case forward. In their answer, they don't address. They never, in 7 years, this is brand new counsel. Counsel came in just for trial. They never addressed there was ever an issue with the contract. They never put forth a defense to the contract. They tried to win on default of saying, you didn't prove your prima facie case. So I believe as a catch-all, whether the contract came in, didn't come in, the plaintiff should be awarded what he should be awarded. The K-1s, he was divested.
Counsel, thank you. Your time is up. Thank you very much. Thank you
Your
both. Cabrera versus Golden.
Good afternoon, close to evening. My name is Peter Taglia. I represent Dr. Golden and his professional corporation. This appeal, like every time I've come before this court, raises a very specific issue. How many facts can an expert ignore? How many facts can they misstate? How many can they cherry pick before their opinion is no longer valid? Well, I think there's so many cases on this. And this court has been very consistent. I'm only going to look at 3. 2 of my cases, Carlton versus St. Barnabas.
Excuse me. So Dr. Winters is your expert, correct?
Yes.
So it seemed to me that he ignored the testimony in the record that the decedent was suffering pain that went from the front of his forehead to the back of his head.
Good point.
And I didn't see that he ever dealt with that.
No, his complaint given to him was pain over the frontal sinuses. The wife, at her deposition, said her husband showed pain going like that. But it makes
Is there any indication that that version of the headache was presented to Dr. Golden at the time of the visit?
Not only no, but listen to, I try to...
Your expert discusses it and says, it's page 604 of the record, while ignored by both experts, the important question is how the patient described his headache to Dr. Golden. The experts used the description of the headache given by Ms. Cabrera at her deposition, page 52 of her deposition above. She indicated that it went from front to back. There is, however, no indication that the patient described it in that manner to Dr. Golden. Was Ms. Cabrera at that doctor's visit with
No.
Mr. No.
To the contrary, the patient complained of pain over the sinuses. But there was something I missed in my brief. The plaintiff's experts, both of them, said the same thing.
I wanted to address another issue that it seemed to me that Dr. Winters didn't address, which was that it wasn't clear to me from the record that whether or not Dr. Golden had ever asked the decedent whether during the 3 or 4 days of this headache, whether he had taken any medication and whether that had any effect on the headache. I didn't see anything in Dr. Golden's record.
It's there.
That showed that he asked that question and what the answer was.
He didn't specifically ask, did you take any medicine for the headache? There's a whole list of the patient's meds, and it ends, patient has not taken any meds. And the only evidence of medication is when the patient went to the hospital.
Oh, wait a minute. That indication that the patient was non-compliant, That was ongoing with regards to his diabetes, hypertension, and everything else. But does that mean that we have to extrapolate from that because he was not compliant with the medication for those pre-existing conditions, that he didn't take Tylenol or something else to relieve this headache?
No, but there's no evidence that he did.
Well, there's no evidence that he asked, right? What's the evidence that the doctor asked and got a response?
But when patient went to the hospital, the wife said that
Answer my
client
questions
prescribed
first. Where's the
Tylenol.
evidence that the doctor asked about the origin of the headache, about the extent of the headache, about whether he took any medication, what he did to relieve it? Where is that in the doctor's notes that he asked and got responses to those questions?
He didn't ask, but it would have been a negative.
How would we know that?
Because the wife said she didn't know if he took Tylenol.
That's the wife. He's dead now.
Well, now you want us to look at what the wife said. A few minutes ago, you didn't think it was
what I'm
appropriate to
saying
consider what the wife said, but in Dr. Golden's records, shouldn't we be able to rely on Dr. Golden's records to find out what he did?
Yes.
And if his records don't tell us whether or not he asked those very important questions, isn't that a factor we have to consider and that your expert should have considered?
It doesn't make the difference between getting a CAT scan and not getting a CAT scan, because you only get a CAT scan if there's red flags. There were no red
But
flags
if you
here.
don't ask the questions about,
That's not a red
excuse me,
flag.
if you don't ask the questions about what might have happened before the headache, what other factors, exactly what the history was of the headache, if he didn't ask those questions,
We know that
isn't
from
it,
the wife's
excuse me, isn't
testimony.
it, if he didn't ask those questions, aren't there red flags that he could have
Tell you why
missed?
no. If someone has double vision, if they have dizziness, they're going to tell the doctor. You don't have to say, you're vomiting. You have double vision.
I don't think that that's the way medicine works. I think doctors have to ask questions because most patients don't know what a relevant piece of information is.
Who wouldn't tell a doctor that they have double vision? Those are the red
So
flags.
you want us to assume
Pounding
that, so are you saying the doctor doesn't have to ask any questions because the
He
patient?
said, tell me about your headache. You would tell him, I have a pounding quality.
And
Red
that's
flags,
good enough? It just to say,
pounding quality. Look at the distortions here. They assumed this visit was for the headache. 6 times. It wasn't for the headache. This was a pre-scheduled visit. They
Why
said
does
the
that matter?
doctor didn't examine his neck.
Counsel, why does that matter, though? I mean, if he shows up with a
Big
headache,
difference.
we talk about the headache.
If you have a headache and you run to the doctor, or you're just mentioning a headache that you had at a visit that was scheduled 6 weeks earlier.
Well, can't it be that he had a visit that was scheduled 6 weeks earlier and then he happened to have a headache and he reports it? What's wrong with that?
But the expert doesn't have a right to assume that he went to the doctor for the headache.
Doesn't matter. He reported it to the doctor. That's the relevant part. The other consideration here is that in terms of the doctor's diagnosis that it was a sinus headache, right? The plaintiff's expert says that one characteristic of a headache caused by a sinus infection is that it is relieved with pain medication, right? A headache caused by a sinus infection does not persist during the daytime and nighttime hours due to change in head positioning. Now, isn't one of the things that the Dr. Golden should have done was to consider whether this was a secondary headache?
Sure, but based on
And
the
answering
complaints,
these-
there's no...
let me ask the question. So don't you need to ask some of these questions to determine whether it was in fact a sinus headache? And there's none of that in his notes. His notes are devoid of any of this information that would have assisted him in determining whether this was a secondary headache.
But he asked him, tell me about your headache. There was-
So it was the patient's
Well, let's assume
responsibility
he's
to
wrong.
answer the questions that the doctor needed answered without them being asked.
The wife said there was none of it. She said there was no vomiting.
But
no
now
nothing.
you're going to the wife. First, you want us to ignore what she says.
No, I don't
but
want
now
you to
want us
ignore.
to listen to what she says.
don't want
but
you
the
to-
point is here that Dr. Golden had the best witness, right? He had the patient. And there is no evidence that he asked the appropriate questions, is there, in his notes?
According to you, yes. But the fact
No,
is...
not according to me. You
Can I-
tell me if I'm wrong.
You know,
Point to me in the record where I'm wrong.
know what this court said in Wong? No amount of questioning would have revealed pertinent information. What could have he asked him? If he asked him, what
Could
did
you
the
have
things they
asked them,
criticism?
how long did you have this headache? When did you start?
what
Did you
did it-
take any medication? None of that would have assisted
You
him
wouldn't
in
have
the
got a CAT
diagnosis.
scan for that. You get a CAT scan for pounding, double vision. You have to have red flags. Those are not red flags.
So you don't ask
Whether
the
there's a red
questions.
flag here, isn't the claim of the plaintiff that what Mr. Cabrera was suffering from was a sentinel headache at the time that he came in?
That's like, that headache is so
No,
severe.
but isn't that their theory of the case that?
That's their theory.
Right, their theory of the case is that what the decedent was suffering from was a sentinel headache, which Dr. Golden failed to realize. So what does Dr. Winter say about sentinel
He said
headaches?
you couldn't have a sentinel headache if you
Just a moment.
drove,
I didn't
ate,
finish the question, and it's not a hostile question even. It's not even a hostile question. So what Dr. Winter says about this, they are typically sudden and severe, often described as thundercap headaches, and do not persist over days. It would be almost inconceivable that a patient with such a headache would have been able to drive to work, put in a full day of work, drive to his previously scheduled doctor's visit, drive home, have dinner, have a normal conversation with his wife about a soap opera, and take a nap. Moreover, the underlying cause of a sentinel headache is unclear. It is widely believed they are caused not by so-called microbleed or a warning leak, but by a physical change in the wall of the artery. I'm not going to go on reading it, because what it goes on to say is that even if you go for a CT scan at that point, it's not going to show you that there's anything going on.
if it's non-contrast.
Also, that statement started off with the word typically, right? It doesn't say absolutely.
Well-
Your own expert says that typically this is what happens.
But the CAT scan, they ignore it. The CAT scan done in the hospital showed inflamed sinuses. Totally ignore it. Totally ignore it. There was only a 4-hour window here. Totally ignore it. And they charged my client with not examining the neck. He examined the neck. You know,
What
their expert
evidence
said-
is there, excuse me, what evidence is there in his notes that he examined the neck?
Yeah, they said he didn't.
I couldn't find anything in the record,
no
excuse me.
JVT,
I
jugular
couldn't
vein
find anything in the record that showed that affirmatively that he examined
It's
the
right
neck.
there.
Counsel, maybe when you come back in rebuttal, you can tell us about that. Thank you.
Good afternoon. May it please the court, I'm Samantha Quinn. I represent St. Barnabas Hospital. The scope of my argument is kind of different than my predecessor. I would like to focus on the
How
issue
did you
of
make
proximate cause.
out a prima facie case? How does Dr. Sammer's affirmation make out a prima facie case?
So in our initial brief at pages 14 to 15, actually 14 to 17, I go through in quite a lot of detail exactly how Dr. Sammer first, the phrase that the court below, or the sentence that the court below focused on, was really an introductory phrase, an introductory sentence, and then he goes on to detail what was done, that it was appropriate.
Yeah,
that it
he
not
did that.
approximately
He
cause
did
it.
that at some length, I agree with you, but where did he describe the standard of care?
He was saying that doing these things in the order in which they were done constituted the standard of care and was consistent with the standard of care.
Huh. Well, I don't know, he doesn't ever say that explicitly, though, as far as I could see.
Well, I don't know that he used the words, those specific words, standard of care, but
Wouldn't that be necessary for us to evaluate and agree with him that the hospital did what it should have done?
well, I mean, he used appropriately and similar language without maybe that precise wording.
Yeah, well, right.
And I mean, he said that emergency department staff at St. Barnabas properly stabilized, diagnosed, performed appropriate life-saving medical interventions, and arranged for treatment and transfer of this patient in a
Yeah,
timely manner.
I'm reading the same paragraph 13, but it just sounds sort of conclusory. It doesn't set out the framework for what should happen when a patient presents at the hospital, as he did, as the decedent did.
I respectfully disagree. I know it's a brief affidavit, but it was kind of a brief presentation and brief issues. And I would like to focus the court, though, on the second issue, which is that even regardless of whether we want to argue about whether there was a departure, the plaintiff can't establish proximate cause in this case.
Counsel, I had a different question about Dr. Santa. I was sort of intrigued by his statement that the times listed in the hospital records don't reflect the times were actually, the times when steps were actually taken. They reflect the times when someone got around to writing them down. So how do we rely on the hospital record if the times in them are not accurate according to your expert?
I don't think that
I'd never seen an expert say that before, so I was
Well, I think
curious.
what he's trying to establish is that this was a catastrophic event that happened. This man came in, he was completely unresponsive. Everything was happening quickly. It was a team effort. I believe he used the words, it was not linear. And obviously, I think the intention of including that explanation was to say that the priority of the practitioners at that point was taking care of this very ill patient, not necessarily writing something down. And so,
But if the times in the hospital record are not accurate, how do we evaluate what steps were taken with regard to the decedent?
well, I believe you can absolutely rely upon the hospital record. I don't think he's saying that it's not accurate. Think he's saying that the exact timing might not be the exact timing of when it occurred. It might be the timing of when the note was entered, which you see in an EMR all the time. This is like when the note was opened. And because they're dealing with an emergency situation, they're not going to stop dealing with the emergency in order to document. I think that was the essence of what he was saying. But you know, even putting all that aside, putting the timing aside, the plaintiff's position in this case is that we proximately caused harm by unacceptable delays in treatment, and that this was a time of the essence situation, except the plaintiff doesn't acknowledge what happened in the 2.5 hours before he came to the hospital, or in the 6.5 hours after he got to Montefiore. And in particular, there's no explanation of how those delays contributed or didn't contribute, and if they didn't, then how can you say that any alleged delays by St. Barnabas caused damages without acknowledging that there were those delays? In fact, I don't even know what happened between 10 to 10:30 when Mr. Cabrera apparently collapsed, and 12:37 when he arrived at St. Barnabas. There's absolutely no explanation as to why that took 2.5 hours. And then once he got to Montefiore, it took 2.5 hours for them to place the EVD, which is not acknowledged anywhere by the experts. And in fact, the experts say it was immediately done. It was not. And then it took over 6.5 hours for surgery to be performed. So I respectfully submit that those delays would need to be addressed in order to establish that there was any proximate cause by any delays of St. Barnabas's treatment.
Thank you, counsel. Plaintiff.
Good afternoon, Your Honors. May it please the Court, Alexei Fagan with Basikas and Associates for the respondents. If I may address the arguments by St. Barnabas first. Certainly, defendant's expert did not make out a prima facie case. I think the case law is very clear that a defendant's expert who merely recounts the treatment rendered and then in conclusory fashion opines that the treatment did not represent a departure from sufficient standard of care does not meet defendant's prima facie burden. And that's exactly what Dr. Sama did in this affidavit. He recites the treatment that was rendered at St. Barnabas, and then in the last paragraph says, well, everything seems to be in order, and as Your Honor pointed out—
Counsel, let's turn to Dr. Golden. The Supreme Court dismissed the claim, I think because it wasn't in the bill of particulars, that he should have sent the decedent for a CAT scan right away, or to the ER right away. Right? Was that just simply a procedural decision made by Supreme Court?
I believe that it was a procedural decision, and I will address that point. In moving for summary judgment, Dr. Owen's expert says that a CT, referring a patient to the hospital for a CT, was not warranted for a myriad of reasons. And again, as the court pointed out, the absence of Dr. Owen assessing the length of time that the patient had the symptoms, the severity of the symptoms, any of that suggests that a CT was not warranted, a referral to the hospital was not warranted. Mm-hmm. Plaintiff countered that by saying a referral for a CT to the hospital was in fact warranted, and the court concluded, well, in the BP, plaintiff did not say referral to the emergency department specifically. What the plaintiff did in the BP was specifically said that the allegation was failure to perform or failure to recommend imaging studies. And that's the departure. The departure—
How else is he going to recommend imaging studies, Dr. Golden? It's 6 o'clock that night. The only place to get imaging studies would have been at an ER.
But I think, again, I think that we're now splitting hairs. If Dr. Golden tells the patient, I am concerned enough that I want you to get a CT scan of the head, then it's on the patient whether he takes that referral and goes to the local emergency department, whether he goes to the local urgent care center, whatever that is, but ultimately, that
Well,
is
in this
on the
case, we
patient.
know that he went from the doctor's visit and went home and had supper.
Because he was reassured by Dr. Golden that everything is in order, because Dr. Golden fails to,
I'm sorry, he didn't, Dr. Golden,
I'm sorry, Dr. Owen.
yeah,
Dr. Golden.
Golden.
right. There were no telltale signs of an intracranial bleed. What's Dr. Golden to do?
Dr. Owen, at the very
I'm sorry.
least.
I'm getting the doctor's names confused.
No, Golden.
Is it
Golden.
Okay. It's gold. It's
Owen Golden, I'm sorry. It's, that's why the patient comes to the doctor. He doesn't know what's causing the headache. It's the doctor's responsibility, and that's exactly
You're
what
certainly
plaintiff's
not
expert.
suggesting that every time a patient comes down to the doctor's office with a headache, and with dealing where he's come not because he has a headache, he comes because he has a pre-scheduled examination. I'm not going to tell you it makes a difference if something should be discovered at that, it should be dealt with. But you're not suggesting that every time a patient tells a doctor, I've got a headache, he should send him for a CT scan.
Absolutely not, but that's exactly why the doctor is entrusted to ask the questions.
So what was Dr. Golden, what happened here that should have led Dr. Golden to think that this patient must go for an emergent CT scan?
How long has this headache been, you've been experiencing this headache? And again, this is long before any lawsuits have been brought. This is the wife now at St. Barnabas.
Counsel, let me just ask you, in that same line of, keep that line of thought. So now he comes into Dr. Golden's office because he's got an appointment. And he says to the doctor, I have a headache. But he went to work that day. He drove to work. He drove from his job to the doctor's office. He's there at the doctor's office speaking to the doctor. From the doctor's office, he goes home, has dinner, speaks to his wife, sits down with her, watches television. Then he goes to bed. What is there in all of that that should somehow raise some suspicion on Dr. Golden's mind that this particular person is going through some type of episode that could result in an intracranial bleeding?
It goes back to what Your Honor had asked with regards to what should Dr. Golden have asked when he was in his office.
But you're taking all of that into consideration, right? Because those are all signs that things look to be pretty good.
But things look pretty good because he's not asking the questions. He's not asking.
But your theory, is it not, is that he was suffering a sentinel bleed? Isn't that your theory of the case?
Correct.
So Dr. Winters refutes that that could have possibly led to the happenings that you're suggesting, because you can't have a sentinel bleed at that point. You would have a thundercap headache, and certainly there's no thundercap headache here. So how do you get past the fact that when he's in Dr. Golden's office, he doesn't have a thundercap headache? So if he doesn't have a thundercap headache, then he doesn't have a sentinel bleed. And it's almost inconceivable for it to be otherwise, according to Dr. Winters.
That's according to Dr. Winters. And we submit 2 expert affidavits who counter that these symptoms that he was exhibiting were not as Dr.
Which symptom is that?
The fact that
the headache is from front to back, there's no evidence that that's what's told to Dr. Golden. That's what Mrs. Cabrera says at her deposition.
That's her observation.
That's her observation. It doesn't mean that that's what Dr. Golden was. Dr. Golden's records don't support that version of
Dr.
events.
Golden's records don't support anything because there's nothing in it, right?
That's correct. Dr. Golden's
They do
records.
support that his blood pressure was taken, and they was given medicine.
And that's great, but with regards to what he presented with, which was a headache, the appropriate questions were not asked, right? Or if they were, Dr. Golden comes to himself.
That's correct. In fact, Dr. Golden testified that typically he documents both positive and negative signs.
So
But
what
in
he
this case, he
documents
decided
is
that
what he
everything.
documents is the sinus condition.
Well, he
And why isn't that a reasonable conclusion
because it's
with this
inconsistent.
patient's
Because
presentation?
one would not experience headache going from the front to the back. Defendants want this court, as well as the lower court,
But there's
to
no evidence
disregard.
that Dr. Golden was told that.
But that's what the defendants want. The defendants want this court to disregard Ms. Cabrera's testimony with regards to how he was feeling when he took medication. If he took any medication, that's okay. But the fact that she's reporting, and again, she's a layperson, and she's reporting that which her husband had been complaining to her about for several days
So
now.
Dr. Golden does find, his finding for that visit is a frontal sinus tended to percussion.
And counsel, doesn't,
Did you have a follow-up question based on that?
And then go ahead.
I have one.
Okay. Judge-
How do you reconcile Dr. Golden's findings, right, regarding the sinuses with the CT scan that's later done at St. Barnabas that finds thickening of the sinuses?
One can have both. In fact, we know that he had both. He had a sinus issue, which was seen on a CT, but he also had a massive hemorrhage. But the problem is that the sinus issue that was found was not causing, could not cause the headache symptoms for several days. And that again goes back to obtaining a history. If the idea was that a patient comes in and it's the patient's responsibility to say, I have a headache, doctor, and by the way, over the course of the last 72 hours, it either got better or got worse when I woke up, or
When you have a headache over several days from a sinus condition,
you can, according to plaintiff's expert, you cannot have it if you are laying down and standing up, because by
do you
virtue
have,
of laying
do
down.
you have the temperature is documented in the record? Do you have that low-grade temperature when you're with the sinus condition or with the intracerebral bleed?
Plaintiff's expert says that that is a sign of an intracerebral bleed. And again, all of these are signs and symptoms that Dr. Golden completely ignored because he didn't ask the appropriate questions. And had he asked the appropriate questions, he would have gotten the responses that warranted a CT on the patient's head.
Justice Rodriguez, do you have a question?
no, I think it was covered.
Okay. Anybody else have any other questions for the plaintiff? Okay.
Thank you.
Thank you.
I want to make 2 points. Judge Gessmer asked, and their expert said, and they're arguing, he based his opinion on the entirety of the record. Well, he said, my client didn't ask about weakness. It's right here. He said, my client didn't ask about chest pain. It's right here. He said, my client didn't ask about shortness of breath.
Tell me what page you're on.
It's page 167. He said, my client didn't examine the neck. It's right here, neck supple, no JVD. You literally would not have to look at the most important note in the chart to come up with these opinions. I kid you not. But I want to read
There's no
something.
indication in that he
I
asked
can't
for.
hear you. I have a
There's
hearing.
no indication in his records that he asked, for example, where the pain was in his head.
Yes,
If
he
it
did.
was
Frontal
where-
sinuses.
But that's the conclusion he drew, but there's no indication of what question he asked. And when we as lawyers interview clients, we don't just say, tell me about your contract. We ask specific questions.
You got a complaint.
And there's no indication here that he asked the decedent
Why
to
wouldn't-
tell him exactly where the pain was,
the patient-
and if it was radiating to another part of his head or anything else.
Your Honor.
Could you show me where there's any indication that he asked that kind of
He
question?
received a complaint. The patient told him, my pain is here.
Okay,
Why would you ask someone, if someone tells you my pain is here,
What does it say that he says my pain is here? What
it
does
says
it say that?
complaint, frontal sinus.
That's a conclusion by the doctor.
No, that's a history.
Does it say that that's what the patient told him the pain was?
Not at all. He found tenderness, and he got a subject to complaint. But there's one line I have to read you before I
Wasn't the
sit down.
doctor supposed to reach conclusions if the patient tells him
First,
something?
he has to ask
Can
questions,
I read one
doesn't
line,
he?
though? I think it's very important. The question here is not whether he should have got a CAT scan. It's whether he should have got a CAT scan. And this is there, and I missed this. This is their experts, both of them, because they're identical. A headache that starts in the front and travels to the back is suggestive of a secondary headache that requires a head imaging study. And I missed it. He didn't say he needs one that night. He didn't say you have to. The question in this case, why an emergency? Not why a CAT scan. Why one that night? Pounding, thunderclap, double vision? None of that was here. This business about going front to back, his expert admitted. That's not a reason to get one that night. Any questions? I'll sit down.
Any other questions for Dr.
Thank you.
Counsel? Thank you, Counsel.
Just two very brief points. In response to your earlier question about standard of care, it is discussed at record at 145. Dr. Sama says that I can state to a reasonable degree of medical certainty that the staff of St. Barnabas met all standards of emergency medical care and the treatment rendered as will be
I'm sorry, what paragraph of that is that? It's 145?
Paragraph 4.
Supplemental record, right?
Of
Yes.
supplemental, yes, as will be
Yeah,
illustrated.
he's saying that, but he doesn't, he definitely says that, for sure, Counsel, but he doesn't sort of like lay out for us what the standard of care is.
Well, he says, as will be illustrated below, the physicians did not depart, and then he lists what they did. I mean, I think this is a question of diction and the way it was phrased, which might not have been the best. But I think that the totality of the expert affidavit certainly meets the prima facie burden. And secondly, very importantly, Judge Capella does not reach the issue of proximate cause. And I urge this court to consider legal causation, and you have the authority to review the record and grant summary judgment. Thank you.
Thank you all. Thank you very much. Okay, last case is People versus Antoine Spencer. Please.
Good afternoon, Your Honors. Paris DeYoung of Legal Aid Society here on behalf of Appellant Mr. Antoine Spencer. Here are the lower court statements regarding the viability of Mr. Spencer's planned defense in combination with defense counsel's misadvice regarding what his maximum sentencing exposure would be, rendered his plea involuntary and thus should be vacated. In response,
In terms of what you're saying the court did to coerce, if I'm using the right word, I don't want to put words in your mouth, to coerce the plea, was that preserved?
I believe it was, Your Honor.
What the court did?
I believe so, Your Honor, yes.
Okay.
My client at sentencing did say, I would like to get my plea back because I believe it was coerced. Now, he did not specify it was these statements by the lower court that made me feel coerced. He gave a plethora of reasons why he felt the plea was coerced, but I think that's sufficient for a layperson. But if this court finds it's anyway unpreserved, we do ask that it be reached in the interest of justice, just as this court did in the Fisher case.
Now, what exactly did the lower court say that was coercive? Because my read of it was, I think the lower court was very careful to sort of explain what the lower court saw in the video, but the court was very, very careful to say, counsel, defendant, you should come to your own conclusions, read the CGI, understand what it is the jury's gonna hear, and then make your own conclusions when you watch that video and see what your exposure is. Wasn't the court careful in that regard?
I don't believe so, Your Honor, absolutely not. No, what the court did here, in addition to making an intention of saying, to my client, you and your family need to hear this, which is how he started. He said, I reviewed the evidence, and he repeatedly identified the perpetrator as my client, even though identity had not been conceded at that point, and then proceeded to say, look, from what I'm seeing, if you're looking at justification defense, what he was careful about was this, I'm paraphrasing what justification actually means. This isn't the CGI. But he made very clear that I don't think that this defense is going to work for you. And appellate courts have reviewed this exact sort of thing where a lower court comes forward and says, I'm going to give you my opinion on your planned defense. And when that's not favorable, other courts have held that that is coercive because of the amount of power that a defendant is always going to give the trial judge, someone who's going to be overseeing their case. I just think it's hard to imagine how anyone would want to proceed.
Well, the judge is going to oversee the case, but it's a jury trial, right?
It is a jury trial, Your Honor, but, well, at least it hadn't been determined at that point, but yes, in theory, if it was. But the question is whether or not a trial judge sitting in front of you saying, look, I know what your planned defense is, and I think you and your family need to hear what I have to say, which is that it's not going to work, whether or not those statements could have motivated in an undue way my client's
Is it
decision.
improper for a trial judge to explain to the defendant what his exposure is?
Well, I don't think exposure was really the question here. To answer your question, no, it's not the trial judge's responsibility to explain to a criminal defendant what any
No, I didn't ask
risk.
if it was a responsibility. I said if there's anything wrong with that.
Absolutely, Your Honors. The role of a
The
trial
is
judge
just to remain silent, call balls and strikes, and not say anything else.
in the plea negotiation process, the role of the trial judge is to be a neutral arbiter between the parties. It is not to step into the role of an advocate, and that is what the court did here. The question is whether or not these statements or whether or not this conversation is one that should have been had by the defense attorney. And selecting a defense strategy and explaining to the client and to my client's family what the risks and nuances in raising such a defense would be, that clearly falls in defense
that you say and
counsel.
explaining to the client's family, because the judge starts off by addressing himself not only to the defendant,
Yes.
but to the family as
That's
well,
correct.
which indicates something. There's some other undercurrent, correct?
Your Honor, I can't speak to that. I think that's speculation. But whether
Sure it is.
Yes. But I think regardless, I think that there's power in that. I think the judge standing before and says, hey, I think not just you have to hear it to my client, but also the family. This is my interpretation of this evidence. It was also coupled with what I think was an inappropriate
There's also
review of
something
the
different in this case, counsel. This is not the judge reading a dry record and interpreting. This is a video.
It is a video, Your Honor, but
There's
first
a
of all,
video.
It is a video, but it's not in the appellate record, so I can't review, and neither can you, whether or not his review was accurate. And regardless of that, as you mentioned, if this was a trial, this was a jury trial, it's up to the jury to determine whether or not a justification defense would have been appropriate, certainly not the lower court. And I want to emphasize that my client pled guilty the very next day, and that's a very significant part of this.
The next day, they had a jury out waiting to come in to start a trial.
That's correct, Your Honors.
And the judge, basically what he did was say, you should speak to your lawyer so that lawyer explain to your client the justification defense and tell him what you see in the video. And then once you do that, you make up your mind whether you want to take a plea or you want to go to trial.
If that is all the court had said, then I would understand the question, but the court went one step further. The court said, I reviewed this evidence, and based on what I'm seeing, you can't do X, and he explained the crime, and then claim justification. He gave a clear review of his belief that that defense was not going to work at trial. That is the distinction.
Did he say it's not going to work or it might not work?
Oh, I think on this
So
record, it's
speak to your
impossible to
client and
interpret
have your
otherwise.
speak to your lawyer and have lawyer explain to him what the justification defense is after you look at the CJI and you've seen the video, so that you're basically you're informed.
Again, Your Honor, if that is all he had done, I would agree with you that saying you need to go over this defense with your client, but that is not the extent of what he did. He went a step further and said, if you're going to take a trash can and you're going to hit someone's head with it, you can't later claim justification.
Well, that's
There's
a little
no
bit more
other
than
way.
that. You forgot the part where he's unconscious.
He was unconscious. Yeah, I'm not debating that the facts here are bleak.
Well,
Your
that's
Honors,
well,
but-
the unconscious part is the whole thing about the self-defense, right? I mean, that's the gravamen of what's happening here and why he may not have a self-defense claim.
Respectfully, Your Honors, I don't think it matters what the underlying offense was. I don't think it matters whether or not justification would have succeeded. The question is whether or
in your
not
view,
that's a proper...
the judge should not have said anything.
The judge should not have given his opinion as to the success of what he knew to be my client's justification defense.
Or
And I
the
just-
probability of the success of that.
I think that was
don't believe that he
entirely
was giving his
inappropriate.
opinion.
I think that was entirely inappropriate, and I just want to direct your... I know that my time is up, but I would
Counsel,
like
you
to
have
just...
time on rebuttal to
Okay.
deal with the next issue. Thank you.
May it please the court, Amanda Regan on behalf of the people, just jumping right in.
Why give an opinion at all?
I don't think that the judge gave an opinion. The judge says no less than 3 times.
Well, but he did say, it seems to me highly unlikely there'll be anything other than deadly physical force involved, given the way this instrument was used and the manner in which it was used with somebody lying on the ground. Isn't that giving his own opinion?
And then he goes on to say, and quote, we can argue about this later, which implies that the judge hasn't made up a decision about whether or not there was justification or not here. And let's be very clear. The judge never explicitly said, I'm not giving you a justification charge. The judge says, let us argue about this later, but he says no less than 3 times, please, counselor, talk about this with your client. Make sure his family hears it too. And that's important because the judge is reminding defense counsel, if this is going to be your planned defense, please make sure that the defendant understands what that defense means.
Don't you think that there's some weight to defense counsel's argument that a defendant there's a jury waiting on a self-defense claim, hearing the judge that's presiding over the matter say, you're going to lose?
But that's not at all what the judge
He didn't say it in those words, but that's the import that a defendant could hear.
No, I
It's
don't.
powerful if it comes from the sitting judge.
I don't think that's the import of what the judge is saying, and I think the most telling evidence that we have that the defendant did not perceive this to be coercive is the defendant's own silence. The defendant makes this plea withdrawal motion, and he lists a whole host of things. My adversary uses the word plethora, but he never ties it to the judge. He's focused on his attorney and whether or not his attorney had misadvised him allegedly about the sentencing range, but he never ties it to the judge. There's absolutely no, other than the timing of this, there's no indication as to why defendant suddenly decided to plead guilty. It's very likely that the reason he decided to plead guilty was because the people finally came down from our original offer, which was 20 years to 18 years. Defense counsel had finally successfully negotiated us down from that. But there's no indication that his decision to plead guilty is tied in any way to the judge's reminder to defense counsel to go over the justification charge. And it's important to note that the judge never said that in connection with, you should go over justification and consider a plea. The judge never said that. And this is very different than the situation we have in People v. Lang from this court, where the judge actually impeded the defendant's defense and said, I'm advancing trial. I'm not letting you bring in this expert unless you can prove to me right now that you have a viable intoxication defense. That was not the case here. This is not Fisher, where the judge says, if you don't take this plea today, I'm sending you away for a very long time. You're going to be an old man when you get out. There's no threats made to this defendant. It's just simply, go over this, review the CJI charge. We have this video, we have this evidence against you. Review that in connection with what the CJI charge is and make sure that this is your planned defense. Just addressing very briefly the alleged misadvice by counsel. There is absolutely nothing in this record beyond defendant's bald assertions that counsel told him he was getting.
You would need a 440 for that, right?
Presumably, yes. Because if even assuming that this advice was given, that would have been a conversation off this record. And we don't have that here. But as the judge pointed out, 40 years to life or 45 years to life was not even a possible legal sentence for the crime which defendant was charged with.
Right, which if counsel told him that that's what it was, it makes it all the worse.
Yeah, but under Mitchell, the Court of Appeals has held that when the allegations made are patently insufficient on their face, which here is the situation, like no further inquiry you don't need to go further. And there's no need for even new counsel because not only are they patently insufficient on their face, but nothing counsel said was adverse to his client's position. I know that there is also a waiver of appeal issue and an excessive sentence issue. I would just note that this is one of the strongest oral colloquies that I have come across in my time in the DA's office, so the waiver should stand, and based on the facts of this case alone, defendant's mid-range 18-year sentence was more than appropriate. Unless your honors have other questions, we'd ask that you affirm.
Your honors, I just want to start because I think it's
quite honestly absurd that my opponent argues that the judge here did not give his opinion as to the justification defense. I'm just going to read a very brief section. The judge says, you get to use deadly force to defend yourself against what you reasonably believe to be the imminent use of deadly physical force against you. So if justification is what's at issue, and I've heard talk about that, then you just have to seriously consider whether the video supports justification. That's all I'll say, because
Isn't that telling the defendant that he and his lawyer should look at the video together and discuss it?
absolutely not, Your Honor, because he follows up by saying, because the video I see shows a very brutal use of the garbage can. He goes on to say, that's all I'm saying, just something to think about, but that's not how I see it. He was clearly offering his own opinion as to how the justification defense was going to play out. Again, I think that there is a line that was crossed when the court went from, you need to go over justification, I want to make sure you understand it, to, I reviewed the evidence, this was a brutal crime, you don't get to commit this crime and then claim justification later, which is, I mean, very closely to verbatim what the judge said here. I also just want to point out the People v. Lang case. That's actually a third department case. It's not a first department case. But there, the court did find that the plea was coerced on the basis that the plea was entered, this is a direct quote, entered on the heels of county court's pretrial analysis, questionable pretrial analysis, as to the viability of defendants' asserted intoxication defense. And if you read the facts of that case, it said, county court compelled defense counsel to lay bare his proof in this regard and thereafter expressed serious misgivings as to the merits and viability of the subject defense. They found that that was coercion. That is the same fact pattern we have here. Clearly, the trial court was laying bare its misgivings, even if you don't want to say flat out was giving an opinion, was clearly warning the defendant that this was not a justification defense that he would put forward. And that is coercive on its face. Briefly, Your Honors, I just want to address defense counsel's misadvice regarding his maximum sentencing exposure. My opponent asserts that there was no evidence on the record, aside from my client's statements at sentencing, that this attorney made such or gave such misadvice. That's actually not true. Not only did my client make statements at sentencing, there was also record evidence that my opponent concedes in the brief that my client sent letters to the court about this issue. Also, my client's wife was there. She tried to make several statements to the court regarding her concerns about the representation by the defense attorney. And instead of hearing her out, the court actually threatened to send her children to ACS instead of hearing her. And then there's also
Is that in the record? Did that?
Absolutely, yes.
Do you have a records site for that?
I sure can.
This? Okay, no, it's okay, counsel.
I can pull it, but if you do look, my client's wife was present, and she says she's going back and forth with the court. And at one point, she says, "Hey, he's got kids," and he says, "If you speak again, I will send your kids to ACS." That is on the record. I also want to point out, Your Honors, that there is evidence here that my opponent simply chose not to address in her brief, that this would have been characteristic of this particular defense attorney, who has been disciplined in several states, including by the court we are standing in right now, for committing similar, if not even more egregious, acts in representing criminal defendants. And so far be it from my client being the only person to make these complaints, there is plenty of evidence on the record that this would have been completely within par for the course for this particular defense attorney.
Thank you, counsel. Thank you both.
You too. Thank you.